Good morning, good morning, good morning. It's, what day is it? June 17th. It's Tuesday. It's day 35. The jury has questions. They're all of us. I have questions. The jury has questions. We have questions. So what happened in court before we went live is that the court read the questions in open court. The attorneys are having time to prepare a response for that because both sides get time to prepare a response. So the court said the jury have questions. They all went to sidebar. The attorneys and everyone got to read the questions. For the defense, the attorneys and Karen Reed. For the prosecution, the prosecutors. Then the court put them on the record, and we are waiting for the response to be given to the jurors. So what we're going to do, we're going to skip the hearings. We're going to skip right to the court reading the questions. Then, if we have time, we will look at what happened at sidebar. Then we will zoom forward in real time to the answers for the questions. We'll talk about what that means because these are questions that the defense is going to be very happy about. Why do I say that? Because I watched these. If they were asking what time is lunch, we're not going live. These are substantive questions that indicate that this jury is working through the verdict sheets and has gotten through a substantial amount of the verdict sheets. That's what these questions are. Whenever you get questions about the verdict sheets like this, you know that they are working. So for those of you that are like, maybe they'll come back with a verdict today, it seems much more likely with these questions and given that where they are. So we are going to roll the intro. We are going to go right to court and hear the questions. We're going to talk about it. And then in real time, we're going to see the answers they're given and answer some questions then too. If they come back, we'll stay here. If they don't, then I will take a break and we will do another stream. It's just going to depend on today. Law Nerds, are you ready? We're going to get to the questions now. Are you ready to go? Let's go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the Law Nerds in the chat. They're here for the facts, not and let's get to court. Did you all get your app notifications? We got to make sure we don't, no app left behind. Court is not supposed to be back for a few more minutes. This is just a few minutes ago, and we are going to see what those questions are. We're going to hear the court read them in. Are you ready? Yes, let's go. Let's go to court. We've got our volume up. I've got my volume up.
Counsel, what I'd like to do is I'm just going to read the questions to you now. So please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right. So I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for.
No, it's not.
Does convicting guilty on a...
No, it's not. It's confusing because the verdict form is confusing, and they want to know if they convict on the DUI, OUI, DWI, whatever you want to call it. They want to know if they convict on the DUI, does that convict on everything up? It's clear what they want. The jury form is not clear for them. It's very clear what they want. It's very clear what they want. If we convict on the DUI, she doesn't get convicted of a manslaughter, right? That is their question. It's very clear what they want. And this is why the defense and the prosecution have time to craft answers.
Subcharge.
We know what they want.
Example offense 2, number 5, convict the overall charge.
No!
What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip.
She modified the verdict slip. She modified the verdict slip. Right. Saying you can go not guilty on each charge. They don't know where to mark that, though. They don't know where to clearly indicate we don't think she's guilty on this one. That's what they're confused about. We want to convict her maybe on the DUI. We want to make sure that that doesn't convict her of manslaughter, please. We don't want to do that. Just give a box that says not guilty each place.
I've given each side a copy. When I come out,
also, if you're ever on a jury and it's confusing, just cross out the charge. Don't check the box, just cross out the charge.
I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they
the defense is going to be like,
and work
give
their
them
way down.
the fucking boxes that say not guilty.
Specifically put in here, but I think it takes it step by step, an analysis to do it.
They want to mark not guilty on the other charges to make it clear.
How much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
The court is off the bench. I think it's clear what the jury is asking. Everything the jury asked about relates to the DUI charge, OUI charge. Everything that they're asking relates to that verdict slip on count 2, the bottom charge on count 2, and can we consider Karen Reed's statements? Karen Reed admits that she was intoxicated while driving. If they are coming to a compromise verdict, which is why I think the defense wanted that OUI charge in there, and they just convict her of OUI, she's facing generally a probationary charge. Yes, you can get custody time on a DUI in Massachusetts, but generally it's a probationary charge. So the defense has to be thrilled with these questions. And do you think the defense is like, we fucking said about the jury form. We've said it. The jury asked, if we convict on the 5th one, which is the OUI, if we convict on that one, it doesn't convict these other ones, right? Because there's nowhere to say not guilty on each of those above it. So I bet the defense is going to argue about that jury slip. So we are going to go to court in real time as best we can, because I think court is just coming back out onto the bench. So I'm going to zoom so we are in real time. The court is just coming out. What means what's going to happen next? Let me tell you what's going to happen from here. Court is going to come back out. The attorneys are going to discuss answering the question. Jury stays in the jury room waiting. The jury will then be brought back out and told the answers once everybody agrees to them. For those of you saying, what is the OUI, DUI? A number of you have asked minimum, maximum OUI. It's a probationary case. It's a first-time DUI. Could they sentence her to prison? The max is 2.5 years in prison. Is that what happens on a first-time DUI? No. It would be probation, fines, alcohol classes, and a license suspension. That's generally what happens on a first-time DUI. So let's go back to court, and then we will talk.
Mention it all.
No.
Mention it all.
Sure, that. I meant Bethany and the gavels are the same color. It's busy today. So I'm sure the defense is going to argue. the verdict form, wouldn't you?
Proceeding, court is in session.
All right, so I will hear you on
All right, let's see what the arguments
first
are.
question, the time of the OUI. Any suggestions?
Your Honor,
can only really give the date.
Do you want to hear from the defense first?
I'll hear from whoever's, you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002,
The prosecution didn't plead a specific time.
section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
I think they can also say
Brennan?
the OUI is charged on January 29th. So the OUI is charged on January 29th.
Or whomever from the Commonwealth?
My suggestion would be 12:45.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
No, there's only a date. You can't give them a time.
The indictments.
The indictment says time. The indictment says date only. I have the indictment. I'm looking at it. It only says the date.
If it's not in the indictment, I'm uncomfortable telling them a time.
Ding, ding, ding.
If it's not in the indictment, I'm uncomfortable telling them
Ding,
a time.
ding, ding.
All right.
I agree with the court on principle.
It's because they didn't charge her with a DUI. They charged the manslaughter and they charged the date. That's all they can give them. They charged the manslaughter. They charged the date. It is alleged to have occurred on January 29th, 2022. That is the allegation.
I just don't have the indictment memorized, so I don't remember. If we can pull that up.
It doesn't have a time. It only has a date. On or about January 29th.
I don't expect that there's any time to be.
All right. So I'll say you have the evidence, and remember, you are the fact finders, or something to that effect.
Tell them it's charged on the date.
All right. Are the video clips of Karen's interviews evidence? How can
Yes.
we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you.
Jackson is full-throatedly in there going, what if any? Give it what if any weight.
Otherwise, it's fine.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence.
That's
Since
fair.
they've been interviewed substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor.
Y'all are asking about the instructions. Don't worry, the court's going to read them. Just hang on. The court's going to read those instructions when they read them to the jury. You're going to have, just give it a few minutes. I want to get through this because then the jury's going to come in.
Is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws and keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight.
She can
So I
just
think
read the jury instruction
appropriate
on witness statements.
Comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
Or you can just read the witness instruction. Oh yeah, the prosecution's not going to be happy with these questions. They know exactly what this means. They've all done this long enough. The jury comes up with these questions because they're ticking through the verdict forms and they get to the last one and they're like, how do we do this? And that's where the questions come up. It's because they've already decided on the things before it. That is the most reasonable interpretation based on my experience of what the jury is doing. Brennan is not going to be happy with any of these questions at all. The court is looking now at the jury instructions, and I think the resolution to answering the question is to read the jury instructions, right? You read the jury instructions and you reiterate the instruction on witness statements because it is a witness statement. The court is going to read in the instructions to the jury when they come back in. So when you were asking about the specific instructions, because I don't have them all memorized off the top of my head and I don't want to misquote, the court will read those to the jury when they come back in. So give us 10 minutes. The jury's going to come back in and the court's going to read it all. So it's okay to not know now. The court is going to look at the instructions. I think the court's probably looking for the witness instruction, and we will see the language of the witness instruction, and the court's going to model whatever she tells the jury after that instruction. She has the instructions on the bench. That's what she was flipping through. And the court is deciding what to do. Josh Adams said, oh, wait, let me grab that. Josh Adams asked if Karen Reed is convicted of an OUI, which is a operating under the influence charge, can it be time served? She didn't really serve any time. They can give her credit for time served, and then it would probably be probation because it would probably still be a probationary case with the normal requirements of a first-time DUI. There's normally a matrix of what a first-time DUI involves: a certain amount of a fine, a certain amount of alcohol-related classes, a certain amount of a license suspension. If she's already had a license suspension, that might count, it might not. But it is probationary stuff. It is very, very unusual that somebody would get custody time on a first-time OUI, DUI if no one found any other harm. So I think the court's looking at the jury instructions now. And again, when they're asking about what time is it charged, it's charged on that day. They could find she was still intoxicated at 5 a.m. and convict her of an OUI. They can find she was intoxicated at 12:45 and convict her. The charge only has the date, and they can base it on her words. So they can absolutely base it on what she says. We're waiting to see what the court does. I'm going to put this at 1.25 because we've got a little bit of wiggle room until the court starts speaking, because the court is flipping through those instructions.
Right. So what I'm going to say is, yes, the video's out.
All right. For those of you asking, can they convict her of a DUI if they didn't have her behind the wheel? Yes, they proved that she was driving through witness statements and through her own statements. She said she was driving. They can prove the whole thing just through what she said. They have more than that, though.
Our evidence.
I'm going to back up
You should weigh the
because I was talking over the court as the court starts talking. This is the instruction the court's going to give the jury. Listen, we'll see if it's the same.
say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first,
That's from the
then
jury
I'll go and I'll
instruction.
read the electronic communications and the humane practice. That covers it.
If the I don't have a
That's from the
principled
jury
objection
instruction.
to it if the court adds the word "if any,"
I understand.
because every single I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is
do.
weighed in and of itself. It's individual to the
They have to weigh it individually as they would weigh any other piece of evidence. That's accurate.
The piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary. And
she's going to model it after the instruction.
They have to give it weight.
She's going to model it after the instruction.
So your objection's noted. Now let's get to the third one.
I don't disagree with modeling it after the instruction. A lot of you have questions about the evidence on the DUI. We will talk about it if we need to. We're going to get through what's going on in court now. We'll answer questions later. So hold on to the questions.
Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2. And I think there are some excellent suggestions by the court in the verdict slip.
Can we go
by
further?
And large,
but
I think
can we do more?
Question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge?
The answer is no.
The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of no, new verdict slips have been provided that will make it more clear, or something of that nature. As well as a decision of guilty on the OUI charge 002, number 5, is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made.
The jury
to the
wants
slip.
to know for sure.
And I'm happy to go over those with you and
That's
put those on
go
the
ahead.
a very reasonable interpretation. The jury wants to know
With regard
for
to
sure.
going from the top to the bottom,
Started at the bottom now.
just under
Just kidding.
number 1. Number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period.
Collaborate and listen.
That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right. I think I'm going to leave it because it appears only under the guilty.
It appears only on...
Under the guilty. So go ahead. I'll hear you further.
Clarify it for them.
Going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent, if you find the defendant guilty of the lesser offense of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them.
That's
Correct.
fine.
Which makes sense. I think we had it in the first one.
It does make sense.
Okay.
And then moving to page
Thank
2,
fucking God.
at the top of the page under sub 4, again,
Hold on
I've been
one
saying it for
second.
2 trials, but yes, that's what they asked for. Right. The jury stopped and asked questions, and they're going to get a form that makes more sense to them.
Okay.
we had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following, and there's a typo. It says the parenthetical
We fixed
says,
it.
Check one of. Okay.
Yes, so we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Yes. Sorry. That was
Right.
me.
After the word stop and sign the verdict slip.
Yeah.
I was letting the Instagram
And
crew
then
know what's going
under
on.
sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the
Oh,
both.
typos happen all the time in verdict forms.
And the final
All the
edit
time.
would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan?
I don't have any disagreement with the
Good.
edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think that the edits, this proposed instruction explains it.
All right. Would I,
I don't have any issue with if you.
Y'all are asking me about the whispering. It sounds like somebody's voice dictating the edits, which wouldn't surprise me, but that's what it sounds like to me. The mics are sensitive.
If you
Or the court reporter's dictation is being picked up. It could be that as well, because we
decide on a lesser included
have heard the
offense,
court reporter before.
the earlier offense. And I'm not sure of the exact language that you use. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form that you filled it out.
Brennan, I'm going to try to gain him up a little bit. When you said you have no objection, just that's when you sit down. It's okay to just sit down. Let's gain this up a little bit
Would be
and see if we can hear him better.
what do you think about the defendant's
Now the court's too
position
loud,
that,
The answer is yes, Brennan. The answer is just yes.
if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of
I
each
think
of
that's
the others.
exactly right.
That would be fine with us.
I think that's
I
the
think
right
it's better
language.
if you find her guilty of any lesser included offense, it would not include
No,
the higher offense.
other way. That's still confusing, Brennan. Stop.
I think that's just confusing.
So what I planned on doing was bringing them out
Alan Jackson and I being like, that's confusing. Stop it.
and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain if you
Started from the
find
bottom, now we're here.
the defendant guilty, you're done. Stop, sign the verdict
Yes.
slip, and let the court officer know you have a verdict or something.
Yes.
Prefer that.
Yeah, I think I'll walk them through it like we do in civil cases.
Walk them through.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should re-emphasize that, and we're not asking for it. That
All
would
right,
be-
so you're waiving it?
We're waiving it.
Okay.
Yes,
All
thank
right,
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and
To edit
Tori, your
those.
computer, to amend this if we can, and we'll make copies, so we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony.
Megalina, will you let the app know that
All right,
the jury
thank you.
is coming in and they're going to be given the answers to the instructions? I'm going to... Tori, computer! I saw it, Coffee Fanatic. Nightbot probably got it because Nightbot will catch the caps. Nightbot will catch the emojis. I think we're set at 5 emojis. I don't remember. The mods will let you know, but if there are a lot of emojis, Nightbot will just swoop it in. But it's because it's hard for me to see otherwise. But yes, Tori, computer. I want to make sure that we are not missing a moment when the court comes back live. So I'm keeping, let me turn this down a little bit. I'm going to keep our comfort fan up in the corner. I'm going to answer as many questions as we can. A lot of you are just coming in. So let's go ahead and tell you what is happening as you are just coming in. And we're going to stay here for a minute after the court gives them these instructions. So If you are just tuning in, the jury had questions this morning. I don't remember exactly what time they asked questions, but it wasn't all that long before I went live. So about 45 minutes ago, the jury came in with a question. So just after 11 a.m. local time. The 3 jury questions all center around the charge on count 2, the last lesser included crime. Let me see if I can pull. I'm hesitant to turn off our comfort fan, but let me show you the verdict forms we're talking about really fast, and then I will put the fan back on. Miguelina, keep an eye on the fan in real time for me, because I'm going to put the verdict form on. Oh, that's the wrong one. I'm going to put the verdict form on the screen real quick. But they are asking about the last lesser included crime, which is just a DUI. It is a standard DUI without anything else, driving under the influence. And while a driving under the influence can carry jail time, it is very unlikely that a first-time DUI gets sentenced for jail time. The general matrix involves fines, alcohol classes, some type of mandatory license suspension if that has not been already done, and some type of probation with limited conditions about drinking and driving. So I am not trying to downplay it. The fines can be expensive. The not having a license can be inconvenient. But given what Karen Reed is facing in this case, which can go upwards of 25 years in prison, a DUI with regard to probation and stuff is going to be a complete win for the defense, because she admitted in those interviews to drinking and driving. So even if the jury does not agree with the retrograde extrapolation test, her words say, yes, I was drinking. Yes, it was this many drinks or around. They estimated that many. The drinks were weak, so I added to them. I mean, I wouldn't have driven on the highway. I was driving slow because I was driving impaired. I mean, I was more impaired than I would have been had I not been drinking. So based on her statements alone, the jury can find it. You also have her saying she was driving. You have her saying she was driving at that time. Her statements alone can convict her of the OUI. If you disregard the blood draw, if you disregard everything else, and then you have the video that backs it up, and then you have the retrograde extrapolation, you have numerous people saying she was getting into the driver's side of the vehicle. So you have people that saw her driving. You have eyewitnesses who saw her in the driver's side. So yes, they can convict her on an OUI. And if they sit there and say, look, the one thing I'm sure about is that she was driving under the influence, then fine. Then fine. And a number of you are asking again, I just talked about the potential punishments for that. So feel free to just doodle me back and then doodle back forward, because we just talked about it briefly. We're going to take a look at what they're looking at. And I want to do this quickly because they're going to come back and read this to the jury. Debbie W., this isn't going to happen. In all jurisdictions, DUIs can carry prison time. That does not happen on first-time DUIs. It doesn't. Can it happen? Yes. Is it the least likely outcome? Absolutely. There is a matrix for first-time DUIs. They involve probation, alcohol classes, fines, fees, and suspended licenses. On the outside chance, they can carry a suspended sentence. So if you violate probation, you can spend 90 days in custody. But no, that's not a reasonable probability. Yes, there is jail time in the matrix, well, in a sentencing matrix, not like the movie, but there is jail time possible. It is not a reasonable possibility here. This is count 2, the manslaughter while operating under the influence. These are the lesser includeds that the jury was confused about. Not guilty of the offense charged or any lesser included. Guilty of the offense is charged, the manslaughter while operating, the involuntary manslaughter, the motor vehicle homicide, and the operating under the influence, and then they can pick A or B. What the jury is concerned about is if they convict, this was their question, if we convict on a lesser included, like count 2-5, then would it convict her of the greater offense? Do you know why they're confused? Yes, you do. because there's nowhere for them to expressly state, we don't think she's guilty here. We don't think she's guilty here. We don't think she's guilty here. Just this one. There's nowhere for them to say it. So the court is going to give them instructions on that. The reason the jury is asking this question, I suspect based on my 10 plus years of jury trials, is because they're sitting there working through these questions, and then they get to the last one and they're like, okay, but WTF do we do? And they want to make sure, if they mean not guilty on manslaughter, they want to make sure they don't accidentally say, we think she had a DUI, we don't think she committed a manslaughter. They don't want there to be a mistake. I think that's conscientious, because there's nowhere for them to clearly say not guilty unless they like write it across the thing. Because they don't have any way to say not guilty other than not guilty of any of the lessers, which isn't what they're thinking. They're thinking guilty on count 5 only. And the jury form doesn't say, if not guilty, go to the next one. If not guilty, go to the next one. It doesn't say that anywhere. And that's why there is confusion. So what is this jury contemplating? I think there is a strong and reasonable inference that they are contemplating just a conviction on the 5th lesser included of the manslaughter. If that's what they're contemplating, they have probably gone through everything else. And that means I expect we will see a verdict today, if not before lunch. And it's reasonable before lunch. Chief Fullbull said, can they write on the form? They are told only to indicate their verdict and sign it. They are told that they can't. So when you are looking at jurors who are trying to do the right thing and trying to fill this out per the court's instructions, and they don't want to make a mistake because the jury is holding on to what they've seen in court, the stress and anxiety of knowing that they make consequential decisions for Karen Reed and for John O'Keefe's family. I don't think the jury's sitting there not thinking about John O'Keefe. I think the jury is sitting there thinking, this was a really good human who deserves justice. But if the Commonwealth didn't show it to us, it's not justice to just convict somebody. It's not. Lawyer, good to see you. If you're the defense team, are you jumping up and down with those questions? Because I saw Sue O'Connell on Twitter say that the defense team was crying. Those are the types of questions that the defense team starts to cry over. Because a conviction on a DUI is a win on top of a win on top of a win for the defense. And they're not asking those questions if they're not considering a conviction on count 2. I had a case that went to a retrial. It was a case that still makes me a bit emotional. It was a very sad case. And the jury came back. It was a killing of a witness, which is, I won't derail our chat. I felt very strongly about it. The witness's family deserved justice. Just because somebody might testify against you in court, you don't go kill them and their mother. So the verdict, the case had hung before, the jury came back with a question. And I sat down at the table and read that question. Ooh, Emily, stop. Read that question and almost burst into tears at counsel table, because the question was, after we render a verdict, can we have security escort us out of the courthouse? And based on what had gone on with the case, I knew that indicated that they were contemplating guilty verdicts. And so you can tell from the questions what the jury is thinking. And when you see a question where you know that the jury is close to a verdict and you know what the jury is thinking, there's no way to understate it. Because for the attorneys in court, if they can tell the family, this is what we're thinking, they have a heads up before that moment in court when verdicts are read. And we were able to make sure all of the victims' family was able to be in court. We knew that we had a verdict. and they came in and it was guilties across the board. The sheriffs escorted everybody out. That I already had police protection on my house because of that case. So it was a concerning case. There were incidents after the verdict. It was a whole thing. So it was a whole thing. Alexis is like, lawyer, you know, and Uncle Jesse in one chat. All of the best hair on the internet is in my chat right now. Yes, that's true. That is absolutely true. So it's nice as a lawyer to be able to give everyone a reasonable expectation of what's happening. And with those questions, the defense has got to be over the moon. It is not unreasonable for the jury to come back and just convict on a DUI. I think there's a lot of conversation that can be had about the DUI being proven. I also think it's why Jackson said a conviction on any of these charges is a win for Proctor. He's like, don't do it. She was driving drunk. He didn't say that. You might be convinced she was driving drunk, but don't do it. Don't do it. Don't do it. But if there are some jurors that are like, it is not right to do nothing, it's fair to convict on a DUI. Did I see that Rob's also in the chat? Hey, Lawn Lumber. Well, all the good hair is up in here. I know you all are like, we have John Stamos, we have the internet famous lawyers. I know the Lawner chat's the place to be. The judge is going to come out. Here's what's happening next. All of you in the chat are like, my heart is racing. Take a deep breath, everybody. I'm sure that the lawyers are ready to cry. Like there's so much emotion. It is such a weird dump of adrenaline at the end of a trial. But the lawyers saw those three questions and know that the jury has worked through the verdict forms to get to that DUI count. It looks like court might be coming back, and they have gotten to that DUI count and they're like, hey, we're confused. When the jury has an answer like this, if the court answers are sufficient for the jury and not confusing, then you will often see the jury just go back to the jury room, fill out the rest of the verdicts form, and buzz that they have a verdict. So we're going to be here for a minute after court is done in case they do buzz with a verdict, because it would not be unheard of for me to do that. Lucille said, wait, the John Stamos. The actual real, yes, the John Stamos is a law nerd. He was in the chat yesterday saying hello. Yes. Yes. The actual one. I know, we need to convince him to tell YouTube to verify his YouTube account. I know, people, we can hook that up. We'll make it happen. So for everyone just tuning in, the jury had 3 questions. We are waiting for the court to come back in and read the answers to the jury. These are my summaries of the questions for those of you who are like, wait, what's happening? These are the summary of the questions. Question 1 is about the time for the OUI charge, the DUI charge. What is the time for the OUI charge? Was it 12:45 p.m. or 5 a.m.? Because the indictment did not charge a DUI and because the retrograde extrapolation showed the BAC, I can understand where the jury's like, well, she went back to One Meadows at 12:45-ish, but she also got out at like 5:07, was out driving around again. I think it's fair for the court to say that the time is, well, 1:29:22, but they didn't charge that count, so they didn't charge a time. And nobody mentioned it in closing because for the prosecution, talking about the OUI is a lose for them. They want to convict on the greater charges. That's why we're here. So the jury wanted to know what time. The court is going to tell them, you have all the evidence, you decide what the evidence is. Question 2, the video clips of Karen's interviews. Are those evidence? How do we consider them? The court's going to re-give some of the jury instructions there and say you consider them like any other evidence. They are evidence. This indicates to me also a younger jury that's like, wait, you can just like use shit she said on TV? What? Like, be so for real right now. What? Yup. Question 3. If we are considering a guilty verdict, does it convict her? Or if we are considering a conviction, I am messing those two up in my head. I don't want to back up and rewatch it because I want to see the judge answer. And I don't want to miss that. If we convict of the lesser, and they said, like count 2, number 5 is the DUI, OUI, operating a vehicle, driving a vehicle under the influence. Some jurisdictions, it's while intoxicated, so it's DWI and OWI. Same, driving while intoxicated. Then does it convict her on the greater charge? Why are they asking that question? Because there's nowhere on the verdict slip to say not guilty on this one, not guilty on this one, not guilty on this one, dun, 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 dun. We are waiting on the verdict, or the verdict. Yes, Emily, that's what we're here for. We are waiting on the jury to come back into the courtroom to be told what the answers are. Then we will back up and take a look at the morning again fresh. For those of you in the replay crew that have gotten here through the chaos, love you so much, replay crew. All the timestamps will be down below. For the one dude who's going to be like, Emily, you repeat yourself. I'm like, yeah, we have 60,000 people here and they come in at different times. So we catch everybody up. Yeah. So we're waiting for the jury to come back in to the courtroom live and be given the judge's further instructions. Let's see. Can you explain one time what is a special prosecutor? Yes, I can, Sandra. We also did it yesterday. We're going to explain it one time today. We saw this in the Alec Baldwin prosecution and Hannah Gutierrez Reed. A special prosecutor simply means it is someone not hired by the prosecutor's office in that jurisdiction. It is an attorney that is not hired by the Norfolk DA's office. When DAs and public defenders are hired, and this varies by jurisdiction with public defenders, Emily, just stick to DAs, the defense attorney contracts can get real complex. When you are hired by a DA's office, you are hired by that office. That is all you do. You work for the prosecutor's office. You do cases for the prosecutor's office. You do not do other things. A special prosecutor is someone not employed by that office who's brought in for the purpose of one case.
All right, so we can bring the jurors over. Tori, do you have those?
I thought we were waiting on the jury. Nope, we haven't even brought the
so
we haven't
Tori
even
will take
brought in the
those.
jury
All right,
yet.
so-
Bring the jury.
all right, so I'll take, thank you.
Amanda, we're going to hear the court read the instructions to the jury together. So we will get there. I know it's hard to wait. We will get there.
Tori, how many did you make?
The chat is reminding me to say, do the YouTube things like the stream. Honestly, I'm more thrilled when you download the app. You can like the stream, that's fine, but also download the app. The court wants to give each juror a copy of the verdict forms to read along. Yes, we want to see it too. If you're not going to put it up on the slide, give each juror a copy. Give each of them a copy and let them read it for themselves. So Tori was making all of the copies, which is perfect. If you are here watching this now and the jury comes back with a verdict before I stop streaming and start streaming again, I am going to send you out another notification. We are going to stay in court for a little bit because when the jury gets clarification like this, it is not unusual that they come back with a pretty quick verdict. And it is noon local time. The court does not take verdicts between 1 and 2-ish. I imagine the court will tell the jury that we will take a verdict before 1. They have time to do that. All the attorneys are in the courtroom. So, yeah, I would imagine that that's what we're going to do. The defense is going to look over this incredibly carefully. This is high stakes for them. Everyone sitting in the courtroom has their heart pounding, I'm sure. There are plenty of trial lawyers in the chat who can tell you their experiences too, but the adrenaline post-trial and while you're waiting for verdicts, even when you have a question that indicates that the verdict is going to be what you hope for, you are still sitting in court with your heart in your throat, waiting for the jury to come in and read that verdict. And if you are this defense team, you have to look at those questions saying, this is, other than an across the board not guilty, this is one of the best outcomes we can hope for, because you don't, in a case where someone is dead,
All right, the court,
you
please. Jury.
cannot underestimate the fact that the jury is like, but we know she was drinking and driving. We know that. And having that option lets the jury say, we know that this is true. We do not have proof on the rest of it. And that is what we're going with. So I think we will see a verdict somewhat quickly after this before they go to lunch. So I'm going to stay here with y'all. Emily, do you need to be packing? No. Who needs to pack? Emily, don't you have to get on a plane today? I mean,
Session remain seated.
yes, but it's fine. I wear
All
black
right,
pants
jurors,
everywhere.
we're in receipt of your question. We
Bring the jury.
The jury is present. The court is going to read all of this together. I'll answer questions afterwards. Miguelina will grab them, put question marks or at me, but
are working on
we're going to do that after.
making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece
This
of
is
evidence.
from jury instructions.
And give them whatever weight you deem appropriate. But first, before you may consider any
is
such
digital evidence
statement, you're going to
instruction.
have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer
That's
to that
The
question.
digital evidence instruction, and that's the
So for the
humane
third
instruction at the end of it.
question, does
The court read 3 of the model jury instructions. She did not modify them. The defense asked for if any. She said, I'm reading the jury instructions as they're written. Those are the jury instructions as written.
convicting guilty
Question
on
3.
a subcharge, example offense 2,
This one
number
matters
5,
more.
convict the overall charge.
No.
So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay?
So she's going to hand out those copies. Rob, totally fair. There's a scenario where the jury goes back, votes, fills out forms, and then eats lunch. Yes. Very fair. After this long of a trial, though, I would be surprised. It depends on how much they like what's being delivered for lunch, to be fair. If they really enjoy what's being sent for lunch, but everyone's in the courtroom, they know everyone's in the courtroom. I don't know. They might just want a GFO. But either can happen. We're going to hang out and see. It's been 8 weeks. So they're handing everyone a new copy of the verdict slip. They might just take their
All right,
sandwiches and put them
so
in their
you'll
bag.
see it really is the same verdict slip, but we've added a little bit of language to help you follow it through.
This is from the jury instruction.
So the first charge, manslaughter while operating a
What she's reading is directly from the jury instructions. They read this trial.
motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip.
Should be but okay.
Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under
Reading it like that, she's going to end up with them putting not guilty in one place and guilty in another place. And then she's going to have to send them back to refill it out.
the influence of liquor. Check one or both of the following. Manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip.
This is from the jury instructions.
That means
exactly.
on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page.
I still think it could be confusing.
Guilty of
for
the
them.
lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following. Motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the
Consider the
influence
next
of
one.
liquor, then continue below to the guilty of the lesser included offense.
They would feel better if they could write not guilty somewhere. They would feel better about it. They would just feel better about it.
Operating under the influence. And you check one or both of the following. Operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater.
They want to be
If you find
sure.
the defendant guilty of operating a motor vehicle under the influence of liquor,
Sign
then
it.
stop.
And stop.
If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses,
Then you
check the
check the
first
top.
box on page 1. And remember, your decision must be unanimous.
She should ask them, does that make it more clear?
Does
And
that
they're all
make it
going to
any
go.
clearer, hopefully? All right, so with that, I am going
She said, does that make it any clearer? Hopefully. I hope they nodded.
remember, your decision must be unanimous.
I backed
All
up.
right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors is sent up,
Sure, why don't you come on over?
They're going to approach real quick. If I'm the defense right now, I'm saying, Your Honor, can you ask them specifically, does that answer your questions? If not, pass a note to the court officer. What further questions do you have? Before you send them back out, tell us. Are we good? They're at sidebar.
Influence
We're
of
in
liquor,
real.
and if they have
Oh, they're rereading something. I thought we were just about at real time. All right, the court is going to clarify again. The defense has to stay on top of this because they don't want the jury coming back and forth all day. They want it to be clear for them.
defendant guilty of the lesser
All right, the court's starting to read that before they even sit back down. We were like less than a minute behind, but
I heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the
they're like, Your Honor, you misread something. The attorneys are sitting there as she's reading it, making notes.
form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right, to the court, please. Jurors, follow me.
Remember, the jury has those forms in front of them as she's talking, which is going to make it more clear. The language that the court read in is much more consistent with the California verdict forms that I know are what Alan Jackson is thinking of. They're coming back onto the record. So we're not going anywhere.
Jury is exited the courtroom. Please be seated.
Are you satisfied, Mr. Yannetti?
Yes, Your Honor.
Okay. I'm going to ask everybody to stay a few minutes. I'll be back out in about 5 minutes.
Yeah, I would.
Well, questions and thoughts and why was
I would 100% stay a few minutes. Okay, the feed jumped back to where we were supposed to be. I would 100% ask the lawyers to stay a few minutes. And if I'm the lawyers, I'm not leaving the courthouse until it's lunchtime. The court's going to come back out in 5 minutes. Those jury instructions are the jury instructions that were read. It is incredibly common that the court answers jury questions by rereading them the jury instruction. That is not unusual. That is generally what courts do unless there's a specific answer. Half the time, the court will simply say, you have all the evidence before you. And jurors are like, what the fuck am I supposed to do with that? Because the court cannot tell you specific answers. Here, the court said, yes, you can consider Karen Reed's videos as evidence. This is how to walk through the jury form. What's the difference in the jury form? I'm going to keep an eye. Let me turn the volume down so we don't jump scare ourselves when court comes back. But I'm going to show you the verdict form one more time and walk you through what the court is saying to the jury when they are looking at this. There is now an edited version of this. This is now edited. But what it is telling the jurors is, in the language they added in, they still did not give a not guilty checkbox. But what the court said, and the jury was looking at this while she was reading, with language now edited in. We may or may not see that soon, but with edited language in there. If you find the defendant not guilty of the offense charged or any lesser included offense, the court told them, then you check the not guilty box and sign the verdict form. If you find the defendant guilty of the offenses charged, then you select guilty and one or both of the next boxes, which are these, the manslaughter while operating under the influence or .08. Hold on. Court, we were just talking. This is why I left the volume on. Hold on. What are we doing? Are we out? Are we not out? Are we back out? Are we just picking shit up off the bench? I think we're just picking shit up off the bench. No, judge isn't back. Judge is grabbing stuff and then judge is leaving. I want to see counsel at sidebar. Perfect. Immediately to sidebar. So they are at sidebar. I'm going to leave this here because we want to know what happens in court. But what the court told them is if you come back with a guilty, you check the guilty, you sign the bottom. If it's not guilty, you go on to the next one. If that one is guilty, you check the box, you sign the bottom. If that one is not guilty, you go to the next one. And so the court said, if it's not guilty, what you do is you go down to the next charge. And you can see it when you have the flow of the verdict form in front of you. So if it's not guilty, the action that you take is to go down to the next charge. And then if you get to the end of the charges and everything's not guilty, back to the top, check that box. I think it's much more clear when the jury has it in front of them. I also think they are probably anticipating that the jury could come back before lunch. It is 12:24 local time. They normally don't take verdicts between 1 and 2. And so if we do not see the jury come back in the next half an hour, we will see if the court takes a lunch break or not. For those of you asking, Beth in the chat said, who are the people behind John O'Keefe's family with laptops? That's the media. Those are, the media's been on a lottery. So if they are standing back at that bar, it's the media. It's actually, this courtroom is such a different setup. Excuse me. Such a different setup. So, Angela said, what if they are just hung on 2.5? We're not going to get there yet because it doesn't sound like that's what's happening. But if we need to, we will talk about it. But I don't think that's where we're at. I think it's very possible that they come back with a verdict before lunch. It's also possible right after lunch, but I think it's most likely that we are going to get a verdict today. Did we break EDB? We are now in week 9 of this trial. My voice is just a little gravelly, and I didn't get nearly enough sleep. Because I'm traveling later today. So things happen when we're on a plane. Let's hope not. Let's just hope that we're done, right? There are some great questions in the chat, and the chat is moving pretty quick. Some of you are going to be like, 66,000, is this the biggest chat you've had? No, not even close to it, but it does move pretty fast, and I want to make sure we grab questions. I try to make sure we grab our member chat, super chats, and questions all together. Question, do the indictments state a time of the charge defense? They all state a date because she was not charged with a DUI. The DUI is a lesser included, which means it's added on the defense request. So the defense requested the lessers. I think it's smart. The defense had the interviews from past jurors. They had a past alternate on their legal team. The defense had a lot of information. A number of you are asking, what about the civil case? I'm not going to talk about whether she has a civil case to bring proactively, but you can still move forward because there are civil cases for wrongful death pending against her. It is a completely different burden. It's different evidence. And so you can have not guilties in a criminal case and liability in a civil case on a wrongful death. So we're not there yet. Those are all questions for later. I want to make sure we talk about what's happening today. So when we talk about civil cases, we'll get to it. Today, we're going to talk about what's going on in court, if that's helpful, because everybody's like, what? The thing that frustrates me the most about this case, and I think exactly like the O.J. Simpson case, the thing that frustrates me the most about this is the investigation that needed to happen for John O'Keefe and his family did not happen. I don't think there's any debate about that. Maybe there is. I can't see it because this was not a good investigation. I've seen a lot of investigations. This one was not good, and that's frustrating.
You do, righty?
All right.
I see everybody's binders are clip-clapping.
All right, so we'll see everybody at 1:30.
We'll see everybody at 1:30. That's in an hour. What do you mean we'll see everybody at 1:30? What are we doing? What are we doing? Are they going to read a verdict at 1:30? What are we doing at 1:30? What are we doing at 1:30? The court's having everyone come back at 1:30. I would imagine the court is sending the court staff on lunch. That would also be my guess. So we have an hour. I'm going to answer questions. I might take
each charge because, as you can see, these are all
That's not what we're doing. No, I give commentary. What? I'm teasing. I've really enjoyed the feed from Boston 10, and this is an update on the individual in court showing the modification. This modification, by the way, is very consistent with the way California forms read. That doesn't surprise me that this is the modification. So, for those of you that need to do stuff, 1:30 Eastern Standard Time, an hour from now, the attorneys have been told to be back in court. So, we will notify you, be back by 1:30. But if the court anticipates a verdict, she might be giving the court staff lunch early. And that wouldn't surprise me either. All right, let me turn the volume off on this because they are now doing reporting out from the courthouse. We will also send an app notification. I am going to answer some of your questions. I will grab some food too. And then that's what we're going to do. So there is somebody saying it's EDT. Did I say EST? I normally say ET because I'm going to screw it up every single time. But yes, the jury, no. The lawyers have been told to be back in an hour. Michelle said, do judges get free lunch during trial days? I have no idea. I've never worked in a jurisdiction where they pay for the jurors' lunch. So I don't know. I have no idea if they do. Not a clue. So I would imagine that when she's telling the lawyers to be back at 1:30, she is anticipating that we might have more happening at 1:30. So here is my plan. We're going to answer questions now. We will put up a break. We will take a little bit of a break, and then I will be back and we'll see what happens together. That is my plan. If you are like, what is happening? The lawyers were told to be back at 1:30. That is an hour from now. That's when the lawyers are told to be back. We're going to answer questions. Then we're going to take a break. California doesn't buy the jurors lunch, not in LA County, which is really tough because there's not a lot of places to get lunch. I don't know if they do elsewhere in California. It's a very large state with very large counties, but not in LA County. They might have changed that. I don't imagine they could. Emily, insert all of your feelings about how much money the county has spent in lawsuits over the last few years. Yeah, they're busy paying lawsuits. They don't have time to, pay for jury lunch. Let's get to questions, shall we? Shall we get to some questions? We shall. We shall get to some questions. Yes, Griffin. Well, Griffin needs me for 30 seconds, chat. So I'm sorry. I will be back for, I get it, Griffin. Thank you, buddy. He was like, I want to clarify, someone else needs you. Yes, yes. I'm going to put up our quick stream break video. I will be right back to answer questions. But when the kiddo needs you in the summer, the kiddo needs you in the summer. I will be right back. Thank you, chat. We're going to put on some music real quick. I will be right back. Where's Dad? We're back now. Let me turn the music off. We are handled now. So we're back. I know we just had a chair stream. It's fine. I did not realize that the video didn't loop. Like, no idea. So let's give a quick recap where we're at. I know I've got my whole recap. All of you are asking, where was Dad? No, B is at an appointment. I thought he was at an appointment, but I wasn't sure if he was home yet and didn't pop in. So nope, we answered questions. No worries. But I love my Guns N' Roses shirts. All right. Let us go back to our question. Yeah, I was asking G where Dad was because I thought he was home. So not home yet. Still a disappointment. Let's get to a quick recap. Then we'll get to Q&A. And then we're going to take a bit of a moment. I know I was trying to answer what G needed. That was the first of my thoughts. So that's what I was thinking. Where are we at now? It looks like the jury is out at lunch. We've got just the only fan. Let's talk about what happened in court. I think for those of you just coming in, we will go back and take a look at what happened in court one more time and answer some questions. Then I will take a quick break. But did we find Dad? No. We did not, because he is still at an appointment. So we're just doing our best. Let's recap real quick, right? The jury came back this morning a little after, I think, 11 a.m. local time Eastern with 3 questions. The court brought the lawyers in. They went to sidebar, which means they would have been shown the questions then. Then the court went on the record, put the 3 questions on the record, indicated that the court was not sure what order the questions were in. They weren't on one piece of paper. They were on multiple note cards. So the court indicated for sure, look, I'm not sure exactly which one happened first, but we are going to just read them in the order and call them question 1, 2, and 3, even though they all came to us at the same time. So no order of priority there. The court read them to the lawyers and then gave the lawyers about 20 minutes to work on answers, which makes sense. The lawyers want to help formulate answers. There's only so much they can say to the jury because you can't invade the jury's role of finding the evidence. So you have to be careful in how you answer jury questions to not direct the jury one way or the other. And oftentimes courts will do that by saying things like, which they did here, you have all the evidence before you. You do. You have all the evidence before you. And you have everything before you that you can consider, et cetera, et cetera. So the courts will also often repeat the jury instructions if that's what's needed. And that's what we saw the court do a lot here, is repeat the jury instruction. So the jury is back. The lawyers are told to be back at 1:30 Eastern. I don't know if the jury is having lunch or not. It's reasonable that they are, but I think if they are, they might still be deliberating. The lawyers were told to come back at 1:30. We do not know exactly why. It could be a verdict. It could be, hey, stay close, but we're going to lunch till 1:30, which means no verdict or anything will happen in court until at least 1:30. So wherever you are, 1:30 is in a little less than an hour from now. So go on. If you need to just come back at 1:30 when the lawyers are told to be back, we'll be back there. So, or we'll be back then. And we'll pin it. Miguelina, if you can put a pinned comment that the court may be on lunch, lawyers will be back at 1:30, because I will take a break and grab some food. I don't know what clock y'all are talking about, but all of those, anybody running a jury clock, it's just the network assuming. No one has more information than what we've got out of the courtroom. And the information we have coming out of the courtroom is the lawyers were told to be back at 1:30. That's it. So if any network is running a clock, they don't know if the jurors are deliberating or not. The jurors were not told to stop deliberating. The court said, I'm going to send you back out. And the lawyers will be back at 1:30. That's what we know. So if anybody's running a clock, they're just doing it on their own. That's not anything that is official from the court. So it's an estimate at best. So it is an estimate. Nobody really knows what the jury's doing right now. They might just be snacking. They might have filled out their verdict forms and be snacking on lunch and know that they can't come back in till later. We're going to sit here and wait. We're going to wait for a little bit. I'm going to answer questions, and then I will grab some food and then finish talking to G about what was going on. That's all. If you are the defense, you are very happy about these questions. These questions indicate to me, and again, the jury can always do something different. They can go back and have a conversation and things can change. The questions indicate to me that the jury is considering the last of the lesser includeds. When you ask, why does the defense want lesser includeds? Because sometimes, especially in a case where someone has died, a jury might want to find something that they can find. And so giving them an option to find something, but not the larger and the charges that cover more, gives them an option. And so some people call it giving the jury an out. Some people call it giving the jury an off-ramp. I say options because it's options. You give the jury options so that they can find a verdict that fits the evidence that they also feel good about versus not being able to come to a verdict at all. You want the jury to be able to find a verdict, and giving them those options, the defense would have talked to their client before saying, we might give them just the DUI. Do you agree? Because those interview clips, the jury might have stronger feelings about Karen Read this trial than last trial based on the interview clips. And if you give them the option to be like, we heard it from her own mouth, fine, give them the option. Give them the option. So if you're saying, you know, Attorney Brennan looks kind of over it in court. Oh yeah. Attorney Brennan is sitting there going, well, that is what that is. Adam Goals in the chat said, was the OUI included in trial one? No, it was not. The jury did not have an option to just find a driving under the influence charge or operating under the influence charge. They did not have that option in the first trial at all. And when this jury came back, they asked questions. What about this? What about this? What about that? They asked those questions. We're going to go back through one more time and take a look at what the court said, because we know the court's out for an hour. So we're going to look at how the court instructed the jury again. It went kind of fast. They did read those different instructions. So we are going to go back to that. If my feed would like to cooperate with me, it'd be great if it does. Perfect. So we're going to go through the jury being read those answers to their questions. They will read the answers. The court will read the questions and read it in. And so you will hear the questions and then the answers to the questions. All right. So that is what we are going to read, or that is what we are going to hear real quick. All right. So let's make sure we've got our volume up. Court will be back to read those. This is a little bit ago with the court instructing the jury and answering their questions.
All right, so we can bring the jurors over. Tori, do you have those?
I thought I was queued up right to the jury coming over. I really did. All right. Let's get to the jury coming over. That's what I was looking for. That is all the attorneys looking at the forms. I thought I had queued it up right. There we go. Because they didn't go to the fan. They went to the flag. It totally confused me. All right, so we're going to listen to this again. We listened to this before.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question,
So those were all those instructions. When you were asking about the humane instruction, that was at the end. You have to find that the defendant made the statement freely and rationally. Also, for those of you saying the court skipped if any, that was a request by the defense. That's not in the language of the instructions. The court read the instructions.
Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay?
And they hand out the verdict forms to the jurors. This happened a little bit ago before the jury went out. They handed out those verdict forms to the jurors to make sure that they could all look through it together. They are all back out at lunch, or we're assuming it's lunch, and they are out for another 45 minutes. So the jurors are getting those. When the questions are answered and asked, the alternates are sometimes called in, but not always. I did not see a report on whether they were or not this time.
So you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip.
So
that means on each
this is reading the jury instructions again and reading the jury instructions while the jury has the verdict slip so that they can go through all of it together with her. But these are the verdict forms and she's reading the jury instructions and the jury instructions on that. So that's what she's reading. This is from earlier. They're out at lunch.
When you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. and you check one or both of the following: operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors are set up, can you receive-
Sure, why don't you come on over?
So the court tells the jury instructions again with the verdict slip, and then puts the language of the jury instruction into the verdict slip so they can see it. And then the defense asks the court to clarify.
Thank you very much.
She reads it back again and clarifies it one more time as they're coming back from sidebar. This was earlier.
Did. So if you go back and
So the court's reading that one more time and then told the lawyers to be, we pushed too far into the spinny wheel. So
back and look at the
there we
I
go.
heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So
Okay.
if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right, the court, please. Jurors, follow me.
All right. The court said we're going to release you to the jury and then told the lawyers to be back at 1:30. So the lawyers will be back at 1:30. The court went to sidebar with the lawyers and told them that. I'm going to keep the volume off on this. So that is a little more than half an hour from now. I'm going to answer some questions, then I'm going to grab some food, and then I will be back. So here is where I think, based on all of my trial experience, the jury is working through their verdict forms. I think we got the jury working through the verdict forms, and if they go in order, count 1, count 2, and count 2 has all of those lesser includeds. And with all of those lesser includeds, we see that there are a lot of things to work through. So let me show you that real quick. They've got to work through each one of these prongs and the evidence that goes to each of these prongs. And with each of these prongs, they seem to be stuck with the thing the defense was arguing over, which is they want to make sure, based on that question we heard, that if they convict on a lesser included, like a DUI, it doesn't convict of the other ones. I think the confusion is that they want to make sure they have somewhere to check not guilty. But if they check not guilty at the top, number 1, it says not guilty of everything. And it sounded to me like the jury wanted to be sure that not checking not guilty is indicating that they're not guilty on those other offenses. If they just click guilty on count 5, it sounds to me that they want to make sure that that just means lesser included 5. That's how I interpret that question. That's what it seems that they're thinking. It would not surprise me if they came back with a guilty on just that. So if the court reads in this verdict form, the court will not read these not guilties. If the jury comes back with a verdict, you will hear the court read the verdict forms, and it will be the verdict on case number, offense, charge. In the above entitled case, we, the jury, say the defendant is, and then it will be either not guilty or guilty, and they will read that. In count 2, when they read this, if they convict of the lesser included, the way it will be read in is generally reading the charge, reading the offense, and then saying, in the above entitled case, we, the jury, say the defendant is. It would not surprise me when we get to count 2 if we hear them read this charge in as guilty of lesser included offense operating under the influence of liquor based on their question. I think the defense is thrilled with those questions. I think the defense feels like, look, we told them that the jury wanted somewhere to click not guilty. The questions told them the jury wants somewhere to click not guilty. The court said passing over it without signing it means not guilty. So then they have an answer to that. Count 3 is the leaving the scene of an accident resulting in death. This requires the most knowledge. And so then they have the guilty and not guilty options. So when and if we hear that there's a verdict today, I would not be surprised if we heard them come back just on count 5 based on that question. And I think that they will be very happy. The defense will be very happy with that. A lot of you have said, but they can have custody time on a first-time DUI. Yes, it carries a maximum potential sentence of 2.5 years. That is very, very unusual in a first-time DUI. And if the jury acquits on all the other things, and that lesser included, it is most likely that it will be treated like any other first-time DUI, with probation, with possibly community service, with fines, with license suspensions, which are normally set out by law, and those kinds of things. So it wouldn't surprise me if they came back on the DUI. It would not surprise me, especially based on the statements from Karen Reed. Because they can look at her statements and be like, okay, that's what it is. But I think the jury asking the questions supports the argument that they were confused on the verdict form. Those are good questions for the court, or for the defense, that the jury was asking the court. So let's get through a few questions. After we get through a few questions, I will take a little bit of a break, and then we will be back at 1:30 to see what happens, and I'll answer more questions because we're going to have some time that we're going to be literally just here. We have some time that we're just going to be here. Let's put back on the comfort fan. Lily says judge could have pre-answered most of the questions if she had allowed the clear juror instructions. The jury instructions are set out by law. The verdict form, there is some room to work with. The court did not agree. The jury asked a good question, and I think they got the answer with those jury instructions. But the jury instructions are prescribed by law, so the court needs to read the jury instructions as they are written by all of the jury committees. They can fashion custom jury instructions. Doing so can be tenuous for courts. If there is a jury instruction on point, that is the jury instruction that's used because it's gone through the vetting process, it's gone through the court, it's gone through the rest of it. So it is not surprising to me. Can't wait to hear your thoughts. I think the defense is probably thrilled. Great question for the defense. It's a great question for the defense. 21 pilot tickets. Laura M., congratulations. Hazen and everyone who gifted memberships today, thank you. You have to show the hot mic. I don't know what we're talking about with a hot mic. I'll go look for it when I take a minute to check in with G and get some food and make sure that Dr. B got home. So we'll do that. Craig Spikes, New York said, I have a question. What is the question? The questions. The jury said, I have questions. You're welcome for the app notification. I like your bun. It's intricate. Thank you. It's just pinned down. So it's holding in there today. I love the notifications for the app. You're welcome. Yesterday, the app had some outages. It was frustrating. The humane practice instruction is what we heard the court read at the end of the digital evidence instruction, saying you have to find that the person made the statement willingly. So we heard that. Emily, get the hot mic when the lawyers sat down. Which time that the lawyers sat down? I will take a look when I go and check in with Griff after the first sidebar, I will take a look. Matt Davidson said, should I be looking at these questions individually or together as a whole? Together as a whole. Yeah, together as a whole. Together, it's clear to me that they're focusing on the OUI. No, Matt, that's a completely reasonable interpretation. Those questions to me said, and this is, again, based on my work with juries, it said to me that they are working through the verdict forms today, that they are talking through everything, and they got to this verdict form, and they got to the end, and we're like, okay, we agree. What do we do? We're confusing. We're confused. We are confusion. So it says to me they've worked through the verdict forms and then hit a roadblock and said, we are confusion. We can't go any further. Because they tell the jury to come to verdicts on each individual indictment. So if they did indictment 1 and are done, and then they get to indictment 2 and are going through it, and they're going like, okay, we don't agree on the operating a motor vehicle. We don't agree on involuntary manslaughter. We don't agree on any of these. We don't agree that she's guilty, or we do agree that she's not guilty on these. We agree that she's guilty on the OUI, which is what it sounded like to me. How do we tell the court that on this form? How do we tell them just this one? And we want to be sure that we do it right. Because what you don't want to do is say we think somebody was driving under the influence and then have it mean that they were guilty of manslaughter. Like, you definitely don't want to do that. The defense said the jury needs somewhere to show it's not guilty on each one. And the jury question seems to say that the jurors want to be able to show they're not guilty with each one. Gigi asked, Gigi in the chat said, what's the difference between the two OUIs? It is, in California, this is the A count and the B count. It depends on the jurisdiction. Operating under the influence and or blood alcohol level of 0.08 or greater. This means that you can be guilty of DUI even without a BAC based on other things. So the jury can find either that she was under the influence. I think that they can find that on Karen Reed's own statements. She said that, yeah, I wasn't as sober as I would have been if I hadn't been drinking, and I was driving carefully because I was essentially buzzed. I'm paraphrasing those statements from her clips because they asked, can we use her clips? Her clips indicate that she was driving intoxicated. So yes, they can. They can say, yes, we think she was under the influence based on her own statements, or they can say based on the retrograde extrapolation, and the retrograde extrapolation did talk about driving time. The retrograde extrapolation was based on that 12:45 time, not the 12:30 time. Remember, way at the beginning of the trial when they were talking about the extrapolation to come up with the BAC, the scientists all had that at 12:45, and we all went, hey, what do you mean 12:45? She was home by then. It indicates to me that the jury was looking at that retrograde extrapolation because it said 12:45 a.m. The scientific testimony said that. And then the time shifted to earlier. So it indicates to me that they were looking at that 12:45 a.m. time on January 29th. And that's why the jury asked, do we find the DUI at 12:45 a.m. or do we find it at 5 a.m.? Because the retrograde extrapolation talked about 12:45 a.m. on January 29th. And I think that's why I'm not talking about real time, chat. Some of you were like, it's not 12:45. No. That's what the scientific evidence said they did the retrograde extrapolation back to. And I think that's why that time is there from the jury. The jury's not basing that time on the Ian Whiffin's testimony or anything else. That time is specific to the testimony about the retrograde extrapolation. So when the jury asked, I think it was question 1, is the DUI for 5 a.m. or 5:07 a.m. when she went back out to drive, or is it from 12:45 p.m.? I think the reason the jury picked that 12:45, also a.m., that 12:45 a.m. time is because that's what the scientific evidence said in the retrograde extrapolation, which found her BAC over a 0.10. I don't remember the exact BAC, but over a 0.10. So, and then it had a window of that BAC. So that's how I think the jury got to these questions. They hit a roadblock. they asked the court. And the roadblock that they hit was on that fifth part. If they had convicted her of anything above that, they wouldn't have hit a roadblock on the fifth one because they wouldn't have even asked the question. If there was a conviction on anything above it, they would have signed the form. There wouldn't be anything else. They wouldn't even ask the question. The fact that they're considering it indicates that they have decided that this is not guilty on the other factors, because otherwise, why would you ask? You wouldn't even be considering it. So, F-Land fan said, that damn verdict form. Katie said, weird, the jury's confused by the verdict slip. Isn't it just? Isn't it just? Isn't it just? The jury was like, we don't get it. And the defense is like, right? Obviously. Okay, you guys have told me before, when they come back from sidebar, is that what we're telling me? When they come back from sidebar, you can hear the defense table. I hate creeping on. I don't think the mic should be on at the defense table. I hate creeping on what the defense is saying, but I will go look. Give me a moment as we get to a few questions, and then I will go look. Travis, pulling it all the way back, said, what if any is a cure-all? A number of you in the chat are asking, what if the jury has a question now? If the jury has a question now, they have to wait till 1:30. So if the jury has a question now, they have to wait. That's what happens if the jury has a question now. Lisley asked, is it normal to have this many charges in one case? This does not feel like a lot to me. So I'm going, yes, you can have lots of charges in one case. I'm going to refine that question a little bit to also, is it normal to have this many lesser includeds? It can be depending on the charge. It can be to have that many lesser includeds. And we can see why they're asking for it. We can see why the defense wants those lesser includeds. Let's see. We've got a few more questions that I'm going to try to get to. If convicted of OUI, will it bolster the civil case from John O'Keefe's family? Not necessarily. It is completely different standards. I think you will see people arguing it both ways, but it's a very different standard. I think the most famous one is looking at the O.J. Simpson case. And if you look at the O.J. Simpson case, he was completely acquitted and then still found liable of wrongful death. It's a very different system and a very different standard. Alan said, just got the news. My hat has shipped. Congratulations. Philip, that is incredibly kind. Thank you, Emily. Thank you, Philip. You're welcome. We are here. So let's see. I'm going to answer just a few more questions. If only someone had told the court the form was confusing. Look, the court is like, court knows best. I'm going to not sing Mother Knows Best because my throat is way too dry to even try. But yeah, court knows best. Court's like, court knows best. Court knows best. And the lawyers are like, please no. Here's my takeaway from it. My takeaway from it is not between the court and the defense attorneys. The jury said, we're confused, and they asked. Good on them. Hey, this is confusing. We should ask the court. And they asked 3 very precise questions. Good for them. Good for them. They asked. Wonderful. So I take this as, look, the jury got confused and asked for help. Snaps for the jury. Good job, everybody. Well done. Ask for questions when you're unclear. Great. That's what I want to see. Loch Nessie said, thank you for the best breakdown and coverage. Always. We're so damn lucky. Look, man. Dave has been playing Idea of You this summer. He has been playing The Stone this summer. He has been playing the list. I am so excited to go see Dave. Have the best DMB. I am so ready. The FOMO I have from some of the set lists I have seen at the tour kickoff. Oh, come on. Just, he's been playing Big Eye Fish again. It's just, and that album was out when I was in law school and I listened to it so much. Emily, is your entire life like spaced by music? Yes. Isn't yours? Like, this song was out this summer. This song was out when I was going through this. This album was out when I was working this job. This album was out when I was working this job. Yes. Yes. And so it is Dave weekend. I am very ready for it. A lot of you are asking where I'm flying out to. I'll let you know. I have a talk with DMB. Not with DMB. Emily, it's called manifesting. It's not a Freudian slip. It's manifesting. Manifest. No, I have an event with YouTube, and then I am heading to go see Dave Matthews Band with some of my lawyer friends. And people are like, what do you guys do? And they're always like, oh, we're research attorneys for her. I'm like, the lies, but I'll allow it because, you know, prosecutors don't always want to tell people what they do for a living, and I get it. So it's just like, we work with her. She talks about law. It's very funny. But yeah, I'm going to Dave with some of my DMB concert peeps, and I'm so excited. It's a girls' weekend. Very, very excited. All right. Law nerds. For those of you that were asking, Emily, what app? The Law Nerd app. If you're just going to hang in the chat, I totally get it. If you're not going to hang in the chat, they should be back in about 20 minutes. If they come back in 20 minutes and nothing happens, know that I will send you an app notification when something happens. I will send you an app notification when something happens. If we hear that the jury has reached a decision, manifesting, say it. If we hear that the jury has reached a decision, I will send you an app notification. Toot sweet. We will let you know all the things. Even if we are still live, the thing with YouTube is that it will only notify you when I go live. So when we stay live and leave the chat open, which I think all of you would prefer, then I will send you a notification so you can go get what you need and then come back. So we will let you know. iOS, I forgot to say, it's in the iOS and Android App Store. It is absolutely free for you. We have so much that we want to do with the app. It's very hard when a lot of us on Team Baker work at the speed of ADHD to realize that that's not like how products get made. It's like, can't we just wave a wand and like do this? And engineers are like, no, no, they can't. Troublemaker Baker said, wait, the fax hat is sold out again. Yes, the fax hat sold out again. We have put in a restock. So the second we have information on the restock, we will let you guys know in the app, and then we will let you know everywhere else. But we will let you know when we have a restock. So we didn't want to sell them and then be like, just kidding, you're going to have to wait. We want to make sure they come in good shape before we put them back up for sale. Niffer, thank you for the gifted memberships, because there's nothing worse than being like, what do you mean I have to now wait? So once we get the hats back in after they're all embroidered, we will let you know. Jessica said Emily takes care of all 60K of us and forgives tardiness. I mean, I'm tardy. Y'all, we work on our own time. It's fine. We have Zoom room. We live life with Zoom room. It's fine. I am going to go grab food real quick. I'm going to check in with G. Don't forget to get the app. Don't forget to set all of the things. And I am going to go grab food, check in with my kiddo. We will be back when court is back. I'm going to be as quick as humanly possible. And I'm going to make sure that I have our lunch break video up. Miguelina, if you don't mind shooting me the link for that, I'll make sure we have our lunch break video up. And then we will go back to court. The lawyers were told to be back at 1:30. Does that mean anything's happening at 1:30? Not necessarily, but that's when they were told to be back. It could just mean that the court wants them close in case the jury buzzes when they get back. It could just mean that. I saw a couple questions. Emily, is there an origin story to Facts Not Fuckery? It goes beyond vibes. It really is the values of leaning into what we know, acknowledging what we don't know, not leaning into the fuckery. And if we do lean into the fuckery for funsies, saying, look, this is fuckery. We don't know this. This is speculation, and being really clear what is known and what is unknown. But it also is anti-sensationalism. I don't want I find it to be fuckery when it's like this thing. It's like that thing's not a big deal. This is normal in court. It might not feel normal, but it's normal in court. We lean into the facts as they're happening. We wait for the answers, even when it's uncomfortable. Not fuckery. And if there's room for fuckery, we call it fuckery. Hey, this is fuckery. Let's talk about the fuckery that's happening. That's fine too. But the value is the facts first. What is happening in court? Why what is happening in court is happening. Treating people like humans. And, you know, if anyone's going to catch smoke, it's going to be the lawyers. They're getting paid to be there. I don't know what city I'm going to, chat. All of you are like, where are you going? I don't know. Charlotte? Charleston? Somewhere. We're going somewhere. One of those places. There's an origin story to that too. The Lawnards know. It was a day. It was a travel day. We talked about it. Things happened. Look, North Carolina, South Carolina. The thing is, I was so confidently wrong, like shockingly confidently wrong. I was like, yeah, obviously. I use them synonymously. Thank God they're close together and I could drive. Lawnards, I'm going to take, 15 at this point. I'm going to take 15. Mods, don't forget to hydrate. Everybody, good to see you. We'll see what happens when we come back at 1:30, all right? Ash said, Emily, are you doing this type of coverage for Coburger? Yeah, we're going to do Coburger coverage. So if you have the app and you're like, all right, let's go. That's what we're doing. Okay, let us go. Let me pull this up. Let's switch videos. Oh, the fan is turned off. The fan is going slow in court. Well, that's breaking news. The fan is going slow and the lights are off in the courtroom. So there's that. All right, there's our vibes. There's the vibes. Those are the vibes we were looking for. Oh, and my screen share disappeared. All the things. All right, y'all, we're taking a quick lunch break. I'll be back in 15. Don't worry. We'll be back. All right, I'm gonna go answer the question from earlier and figure out what's going on. I will see you guys soon. Lawnards, get food, hydrate. Court days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during Verdict Watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, take care of yourself. Trial days are long days. trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Court is still on break, but don't forget to download the Lawnerd app so you know exactly when we're back from break. The Lawnerd app has all of your live court notifications to keep you in the loop. Take care of yourself, trial days or long days. All right, y'all. Court is coming back. We're going back. Let's see what's happening. We'll have to turn the music off. Let me switch feeds. And we are going to go back to the court coming on to the bench. I don't know what's going to happen, so let's see. Let's go. Court is back in session. The Law Nerd court is ready. EDB didn't get enough to eat, but it's going to be fine because who knows what's going to happen next? We don't know. Hold on. I need my live court. We're in live court. All right. Let me make sure we're unmuted. Let's.
Session.
You are unmuted. Court
All
is
right,
now in
so
session.
I'll see you at Sidebar so we don't do this part.
Mother. I have nothing to throw. Emily, what the fuck's wrong with you? Why don't you just expect that this is what's going to happen? Your expectations are not reasonable, EDB. You expect that something's going to happen without a sidebar? Girl, we need to reset those expectations.
Jim, can I have that question, please? Thank you.
It sounds like there is another jury question.
All right. So as counsel knows,
Many of you heard there was another jury question. It wasn't going to come back till everybody was back from lunch. Another question. Let's see.
we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge,
No!
is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at Sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not certainly not.
No, you need to tell the jury if you have rendered verdicts, then you need to fill out those verdicts. Ooh, I hate that question.
I agree. You can't ignore your question.
You can't ignore it.
However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your...
Hold up. Come on back, everybody. Did you hear what Jackson just said? Given that that came back before the other questions. Hold up. Given that that came back before the other questions, then I think we should ask if this question has been resolved. You heard what Jackson said. That changes literally everything. That came first. Did you hear what he said?
When that question came in, literally before...
I'm backing it up.
This position is not certainly not for it. I agree. You can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's...
Based on what Jackson is saying, here's what I think. That question came in while they were waiting for the answer on the other 3. And they didn't have the answer on the other 3. So they wrote the 3 on the note cards, then they waited for more than a half an hour, and that question came in while they were waiting for the answers on the other ones. So the timing of that means this question came in while they were waiting and wasn't addressed before lunch.
Clarity in your other questions. Does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated.
I think you just asked them, Is this still a concern?
A little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than one count, but they're hung on a separate count, they are to report those two counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point. It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
I think you should ask.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson.
She's
I'm not going to
ignoring
have
it.
a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
But I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we can't answer it.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to...
Jackson was the one talking to you. Why are you now looking at Yannetti being like, I'm inclined to answer it? You're talking to Jackson. Answer to Jackson. Just
confer with counsel, Your Honor?
yes.
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute. Thank you.
Here's the easy solve for this, you guys. Here's the easy solve. After answering, hey, everybody. After answering your previous questions, do you still have this question? That's it. Or don't respond at all and see if they've resolved it. Because if that question came in while waiting for answers, it's very possible that the answers have already resolved this issue. We are just a touch behind real time, so I'm going to put this I'm going to speed them up while they are conferring. And then when we are back on the record after they confer, we will go back to normal speed. Jackson is asking for a very slight modification to that.
Just with a very slight tweak with the court's language, I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer.
You
for the
can,
reasons I
though.
stated. It's theoretical, and we tell jurors that they can.
The whole feed yeeted itself. It's not. You can answer this question, though. You don't want to answer it yet. But this is a question the court can answer. Telling them you can't answer it is going to dissuade them from asking future questions. We can't answer it at this time.
Cannot be concerned with the consequence.
I hate everything.
The reasons
about
I
this right
stated
now.
is theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would
That's not a consequence question.
be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah, I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer,
Yes.
the court's indicating that it doesn't answer questions about the consequences of the juror's verdict.
And that's not what's being
punishment. Of course you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict.
Yes.
So I think saying I can't answer this is sending a false message to the jury.
Yes, I agree.
If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. certainly as far as our concerns, and it protects Ms. Reed's rights. I think that
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same
this
thing.
time.
Is there an objection?
Yes.
I understand, Mr.
it's important to
Jackson.
add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
At this time. She's not going to say at this time. Just give the jury the answer. This is a question you can answer. The court can say,
Allow the court to finish writing, but
the court can say in jury instruction number this, you are told. However, this is theoretical. Everybody breathe. I'm stressed out too. This is theoretical in that this question came in while they were waiting for the other answers. It is much more likely that the other answers cleaned up this question.
at this point, that is over our objection. I
understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights. I
Okay.
think this way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
there's
say to ignore anything, Your Honor.
All right, we are all set. So let's send this in, please.
All right.
Well, that's why the attorneys were back at 1:30. Let's summarize and then we're going to go watch again. Shall we? Everybody breathe. Because it's most likely that this has been resolved. So, the jury came back with another question. What we learned from the way that Alan Jackson responded to the question is that the question the jury had, what happens if we reach verdicts on some counts but not all of them? Do we just render a verdict on some of them? Jackson said, look, this came in before we answered the questions on the other three. To me, that indicates this question came in the waiting time from the first three while they were working on answers. And then they answered those three. It's very likely that the answer to those three questions resolved whatever dispute was happening. So then you hear the lawyers arguing over what the answer should be. And there are times that the defense is too hyperbolic. This is not one of those times. You can tell the jury that they are to render verdicts on any charges they reach verdicts on. It's in the jury instruction. You could also point them to the jury instruction. Jury instruction, this says, if you reach a verdict, fill out the verdict slip and sign it. The jury instructions say it. She could just say, this question is answered in jury instruction number, whatever number it is. They all have numbers. Or she can bring them in and say, you asked this question, jury instruction, this is your answer. Or she can say, after we answered your last questions, has this question been resolved? There are lots of options other than I can't answer. The problem the defense is having is the court is saying, I can't answer because it's hypothetical. It is a what if. However, there is a jury instruction on point. Just point them to the jury instruction. Just point them to the jury instruction. Let's go back and hear the jury question. It was a very clear question about what happens if they can only reach a verdict on some of the counts. I would suspect that the answer to the other questions resolve this. That would be my suspicion. Let's take a look again for everybody who's just coming in. Hi, welcome. The jury had another question. It seems that this question happened in the intervening time between questions 1, 2, and 3 getting asked and getting answered. That is how I read this based on the information we have. So the jury sent question 1, 2, 3. It took more than a half an hour, well more than a half an hour, probably closer to 40, 45 minutes for them to get an answer. It seemed that this question came in that waiting period before those questions got answered. So let's listen to question 4 one more time without me screaming and going, what is happening?
Please be seated. Court is in session.
All right, so I'll see you at sidebar so we don't do this part in open court.
And that is telling them what the question is and when it came in. We're going to zoom past the sidebar.
All right, so as counsel knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially.
That went fast. We're going to listen to it one more time. This came in the intervening time.
On 2 charges but can't agree on.
And I do not have this sped up. The court is reading this quickly.
If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply.
And I disagree. That's not asking about the consequences. It's asking about what do we do? I read this as the practicality of what do we do? I don't read this as the consequence of our verdict. I read this very much as what are we supposed to do as a practical matter? As a practical matter, how do we answer this? Do we just fill in the verdicts? There is a jury instruction directly on point, and that jury instruction says, once you reach a verdict on an indictment, sign the indictment. But the jury is clearly wondering what happens if they can't reach an agreement on everything. I also hope that the questions or the answers on the lesser included resolved this.
Is it a hung jury on?
But this is exactly where we were, trial 1. Exactly where we were.
We received a question
I'm going to
from
hear
the
it one more time.
jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me,
we're going to listen to the rest of the answer. She can answer this question. I just disagree. This doesn't involve consequence. It involves how to fill out the verdict forms.
it's a theoretical question, and we don't answer theoretical
little theoretical
questions. I tell the jurors that they're...
But here's the thing. The jury said, if we reach. The court would answer this differently then if the jury said, if we reached verdicts on 2. So you would answer them differently if they said, if we reached verdicts on 2 charges and can't agree on a 3rd, versus if we reach verdicts on 2 and not on a 3rd. Okay.
not to be concerned with the consequences of their verdict,
They
and
want
that's
to know
exactly
how
what
to
they're
fill it
doing
out.
here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not certainly enough for it.
We're going to listen to the whole argument again. Because it, A, haven't passed and everybody's stressed and court's on break. So we're going to listen to it again.
I agree. We can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, which was literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words,
It's in the jury instructions. You can just give them the jury instructions.
I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our
it's just a
options?
practical
And
matter.
the options are built in the law, not in theory. If they come back with a verdict on more than one count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most
It's not
appropriate,
consequence
and
related.
We would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
But I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't
That's
think
the
the court should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say this question is
The court can answer this question. It's a question asking if they can render a split verdict. And there are jury instructions on point. She can answer the question. She's not answering the question at this time, but she can answer this question.
not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Well,
Not if the
what
jury
those
doesn't
steps are, I
ask.
think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer it.
So I don't know if I want to put you in an uncomfortable position, Mr. Yannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor?
1 minute.
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute. Thank you.
I told you yesterday how judges feel about people being late in their courtroom. Lost time and all that. All right.
I would simply don't have
This is our second watching of this, so I'm zooming ahead of that. It is our second watching of this argument because then the court answers. We'll talk.
just with a very slight tweak with the court's language. I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan?
You said
My
it.
response was this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict. And
That's not a
exactly
consequence.
what you would be asking me to endorse. What's the Commonwealth's position on the proposal?
She sees it as a consequence because they're asking if we are hung on one, what does that mean? I see it as a procedural question. She sees it as they're asking what happens if they render verdicts. I think they're asking if they can. Can they render a split verdict? Because they're saying, if we reach verdicts on some but not all, does it mean it's hung on all? And the answer is no, it doesn't. If you reach a verdict on an indictment, fill out the verdict slip. That's what it means. If you reach any verdict, fill out the verdict form. That's what the jury instructions say. I wonder if the defense had asked, Your Honor, can you just cite them to the jury instruction? If this would have gone differently. She sees it as the jury is saying, well, if we do this, then what happens? I see it as they're trying to say, how do we do this? I also think this is probably not an issue because of the 3 questions that they asked and got answered. I'm hoping this truly is all theoretical. Truly.
Post.
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address.
Ross, this is like our 3rd watching. We're not so far behind. But you can go watch The Fan.
At this time,
We're talking about this.
That assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that.
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
Add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
Okay. She's answering it and sending it back. I don't agree with the way she's interpreting it. I understand what she's saying. I just don't agree.
At this point, that is over our objection.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer.
I think they're
very,
so
very
frustrated. Of course
clear
they are.
question that could be answered in an innocuous way that does not affect Ms. Reed's rights.
Just
Okay.
send them to the jury instruction.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
there's that.
to ignore anything. Your Honor.
All right, we are all set. So let's send this in, please.
All rise.
The court's like, I'm not fighting with you. Goodbye. Goodbye. I can look. Today's an emotional day. I am sure the defense is frustrated. I am sure the defense is incredibly frustrated. And look, we're back in real time to just the fan. Shocking. Of course the defense is frustrated with, of course they are. How could they not be? The defense is frustrated because they are concerned about the exact same thing that happened last trial. They are concerned that the jury will not understand how to render a split verdict. It is my hope and suspicion that perhaps after getting the other answer, then the jury has moved past this. But their question was, if we reach a verdict, I'm going to read this verbatim because Ted Daniel put it up on the Bird app verbatim. If we find not guilty on 2 charges, but can't agree on 1 charge, is it a hung jury on all 3 charges? I think that the jury is asking how. And I wonder if the jury, and this is what's difficult with jury service, right? Because if the courts want the jurors to use language like a lawyer, they're not going to get that from a jury. If we find not guilty, if they had said, if we found not guilty on 2 charges, would the court have answered differently? And I think they would have. If we found not guilty on 2 charges, if that was the question, that's not the question. They said find, not found. So if it was in a different tense, then it's no longer theoretical, and the court has to give the jury instruction saying, if you have reached a verdict on a particular indictment, sign the verdict form. I hope that this is, because this came in between the waiting time, I would suspect that the 3 answers helped the jury move past this. But we don't know what they were talking about being unresolved on, but based on the other 3 questions, it might have been the DUI. Can we use Karen Reed's video? Maybe there's some jurors that like, well, she said it. Okay, but can we just use that as evidence? Is that fine if she just said it? maybe those questions answered it for them. The judge is like, you're asking me about consequences of the verdict by saying, if we find not guilty on 2 but can't agree on the 3rd, is it hung on all 3? The court can answer that question with the jury instructions. I don't see it the way she does. I don't see it as asking for consequence. I see it as a jury that is confused by what, chat? The verdict forms. Are you shocked? Are you shocked? They are trying to walk through the verdict forms, and they aren't sure what to do. Shocking. Shocking. So I disagree with the court's interpretation that that's asking about a consequence. It is very hard to be the lawyer in court on this type of an emotional roller coaster day to deal with a question like this. I wish Alessi had been like, ask her to just read the jury instruction. She might have been more amenable. But that means the defense needs to have their jury instructions in front of them in court and say this. I understand the frustration. And in that verdict form on count 2, they have nowhere to indicate if they're not guilty on some of the charges without indicating that they're guilty. They can't say if they were hung on a lesser included. There's nowhere for them to really indicate that. Their options are not guilty on everything or guilty on some of these. And I think that's frustrating for them too, because if the jury wants to say, no, we're not guilty on this top charge, we're confused on these lower charges, I think they want to render that verdict, right? Here's the thing. The jury is asking questions. And their questions are, I think, fairly straightforward. I find those to be fairly straightforward. So I'm going to go look and see if there's any answers on why the court didn't read these earlier and see if we can find out why, because I am confused as to the timing on that, and see if there is an answer for that. Let's see. There is no, I don't see any indication quickly or clearly about why that wasn't addressed when the others were. And I wonder if it's because it came in the meantime, but that. Fair Green said, what were the other questions? We went thoroughly through the other questions earlier in stream, and there's timestamps, but the jury asked 3 questions about the DUI. The court came out and gave them instructions before we took the lunch break. So Luffy said, official motion for multiple goat screams. I mean, it is needed. Hold on, let me try to grab that. It is needed. What in the world? What in the world? What in the world? Also, for those of you just coming in, I understand we reconvened at 1:30 or 12:30 my time when we knew the court would be back. And then we also sent out an added app notification when we knew that the court would be addressing another jury question. And then how those get delivered depends a lot on cell phone carrier. So we do our best when we know, but we didn't know if the court was going on the record till the court went on the record. The court told the lawyers to be back at 1:30. We did not know why. So there was not too much we can do. With that, we are just here to see what the court is doing. So we now are back in a wait. I am going to leave the fan on. I'm going to answer some questions. When we get to the end of questions, we will reassess how long we hang. So I know that it is frustrating. There is nothing we can do about it. The attorneys in court are competent attorneys. They are experienced attorneys, and everyone's emotions are heightened. I get the frustration. There are a lot of ways that could have been handled. I don't like the way it was handled either. Judges get to make these calls all the time. There's not much anyone can do about it when it comes to answering a jury question. Here is what I think. I think that question is probably moot. Truly. I'm frustrated with the way it was answered. I think it's probably moot. Truly. I hope that the questions that were asked before lunch clear that up. That's where I'm at. Sunny said, I think the jury should be able to view the entire Karen videos if they're being used for evidence, not just the potentially misleading clips. Sunny, I understand the rules of evidence disagree. The defense cannot put in the clips that they want. The Commonwealth gets to choose what they want. The only way to prevent against some of it being used is truly by not having any media clips. But no, the whole thing does not come in just because part of it comes in. I was trying to move our fan up a little so it didn't get covered by our questions. But the defense can argue for completeness. They do not get the entire videos. Those are not evidence, and the defense can't put them in evidence. If they wanted to put the evidence in, then Karen would have had to testify. And that comes with a lot of downsides. The only real way to assure that those aren't used is if you don't do them, because the Commonwealth can use them. They didn't last time. They didn't have as many of them. But I do think that the answer to the other questions probably handled it. So LB said, it's almost like the defense knew this would happen. They knew there was confusion with the verdict forms, and you can see where the confusion is. You can see where the confusion is. Alessi is about to pull out a verdict form with quilty, not quilty, in the boxes in the next 15 minutes. But yes, he might pull the guilty, not guilty. Though I think those are the cues, the G's, not the Q's. My brain is not reading them right. But yes, I think Alessi's ready to be like, this one. However, the court did modify the verdict form. And so the questions that the jury had should be answered from the earlier questions. Amy, good to see you, said, of course they had questions on the verdict form. Our civil jurors have questions when we have a 2-page verdict form asking only 3 or 4 questions. It's a lot of questions to go through. It is a lot of questions to go through. Lulu87 said, asked if Karen Reed's license is already suspended. I do not know. It may be, it may not be. It can operate differently in different jurisdictions. When we were talking about the potentials, we were talking about all the potentials. If that's already happened, there might be a limit on how long that can happen for. It decides. It depends. Claire said if she is convicted of something, who sentences her? The court. So it would be this judge. Kelsey said, hi, Leonard's just dropping in before this baby comes. Labor is in full swing. Congratulations, Kelsey. You've got time. Don't worry. It's going to be fine. He will be here today. So happy he's heard EDB's voice leading up to today. Well, we are here streaming so you can hang with us while you are walking through the things. Carrie said, as funny as it would be to send Jackson and Unetti a I Survived 2000 What If Any's shirt, it would probably be improper. I don't know how they would see it, but they probably wouldn't be able to wear it because it would be used in other trials to be like, see, the defense is doing this. So we would see. 22SCHG in the chat said her license is suspended. She said it in an interview. It's why she stayed in a hotel closer to court. That makes sense. I didn't know, but if she said it, then that's what we've got. Melissa asked, EDB, how long before you fly? We've got a little bit of time. Christina said evidence yet, but she is not under oath in those clips. And that's why the court gives that digital evidence instruction and then deciding if it was a coerced statement. This may be a reach of a question, but do you think this means the jury has decided to convict her of something? Becca, the earlier questions, I think, indicate that they were contemplating that DUI. And it seems like they are still contemplating that DUI because they have not buzzed back yet. The court is in recess. The jury is deliberating, and they have not buzzed back. Meg said, Brennan looks defeated. So does Lally. Hi, Mom, watching at nearly 2 a.m. Aussie time. And I translated that right into American. Hi, Mom. It just happened so fast. But yes, we're going to wait for a minute and see if the jury buzzes back because, well, the jury is working. They had multiple questions this morning. They got answers. They took lunch. They're back now. We're just going to have to wait and see. I don't know if the defense left the courthouse. If I was the defense, I'd probably stay close to the courthouse. I don't know if the court told them to stay close. A snake named Michi said from Massachusetts, thank you so much for following this case. Me and many I know are very skeptical of our state police and court system, which is an awful feeling. It would absolutely be an awful feeling. The verdict will have a deep impact on the people of Massachusetts. I think the verdict will have an impact, well, verdict or lack thereof, will have an impact well beyond Massachusetts, because a lot of people are watching going, what is happening? So, Jackie said, will she read them as agreed? It seemed that the court read in what was exactly in the jury instructions, not the modification. Tonk, this was a question from earlier about the DUI and the blood draw. Yes, they did the retrograde extrapolation. Those witnesses testified way early in trial. Average cheese lover. I mean, who doesn't love cheese? I mean, I guess if you really can't eat cheese, maybe not, but cheese. Midnight here, but can't sleep on verdict watch. Today's been a very active day with this jury, so I understand. Brandy said, what, if any, are the reasons anyone wouldn't want the clearest verdict form possible, including the Commonwealth and the judge? If this is the verdict form they always use, courts are very reluctant to deviate from the norm. I find that is more true when you are dealing with attorneys from out of the jurisdiction. You can end up with a little, don't come to my house and tell me how to do it. This is how we do it here. We're not in California, Mr. Jackson. We're not in New York, Mr. Alessi. So you can end up with some of that. This is how we always do it. It's fine. Well, twice now there's been confusion. So clearly it's not fine. If there wasn't confusion, there wouldn't be confusion. Gracie asked, and a lot of you asked in the chat, does the OUI first offense carry jail time? The jail time is a potential possible sentence. It is very unlikely as a sentence. It is a potential sentence, but these are much more commonly probationary sentences. Probationary sentences with community service and fines and classes and license suspension and things like that. But yes, DUIs generally do carry some level of jail time. And in Massachusetts, that's true as well. But it does not carry a mandatory jail sentence. Probation is on the table. There are a lot of charges, some that Karen Reed is charged with, that carry a mandatory minimum sentence. A mandatory minimum means that you have to serve that amount of time to start, and then you can get more. It's like a floor and a ceiling. With probationary cases, you can get probation or up to this amount of custody time. So it's probation and up to an amount of custody time. That's unusual. So it's, again, I'm sure the defense is more worried about the jury rendering a verdict at this point than what would happen with the OUI. Sabrina asked earlier in the day, does this indicate we are getting a verdict today, possibly on the OUI? I would suspect yes, but now I'm also nervous. A number of you asked, why would Karen Reed's license be suspended? Sometimes you have a license suspension as a default by the DMV if you have a driving related offense. And Karen Reed has 2 drunk driving related offenses in these charges. 3. Hold on. Let me look at the indictment real quick, because the first one, the murder in the second degree, does not have driving under the influence language. The second count is specifically driving under the influence resulting in death. And then the third one is the hit and run. So that second offense very well may carry a lifetime. If you are convicted of the second offense, it very well may carry a lifetime license suspension. The DMVs will oftentimes, if you are charged with offenses like that, automatically suspend your license until it's resolved, especially if it carries a lifetime license suspension. I'm not saying that it does. I'm saying it very well may. So yes, this is not a normal DUI. It's a manslaughter while operating a motor vehicle under the influence. It carries a mandatory prison. That charge carries a mandatory prison sentence. And given that it's a mandatory prison sentence, I wouldn't be surprised if it carries a substantial and or lifetime loss of license if you are convicted of it. So that is a reason that your license may be suspended until it's resolved. With other DUIs, oftentimes when you're arrested for DUI, there's an automatic license suspension that happens before you resolve it in court. That's not uncommon at all. Let's see. This is a great question in the chat. I think it's speeding by, but let's see. Where did it go? It went. There was a great question, and I saw a question I really wanted to answer, and then it jumped, which happens. There's a lot of us in here. Darn it, I completely forgot where it went. I'm not going to answer any questions about the jury not being able to reach a verdict because I would very much like for that to not happen. Let's see. The jury form was already amended. Yes, it was. I'm just trying to answer all of the questions. Baby T said, but it's up to 2.5 years in jail for OUI. Yes, but it's very unlikely on a first time. So yes, there is a maximum sentence, but yes, it is unusual. Marcy asked if convicted on an OUI in this case, can she appeal it later or does everything else come with it? If convicted of an OUI, yes, you can appeal it if you want to. I mean, there's so much time and energy in that. It might be faster to do probation and move forward. DML said, was the OUI brought up during her grand jury? Yes, in that it's a lesser included. To indict someone on count 2, the manslaughter while operating a motor vehicle under the influence, a grand jury has to find that you were operating a motor vehicle under the influence. So yes, the grand jury found count 2, manslaughter while operating a motor vehicle under the influence. That charge necessarily includes a DUI. That's why it's a lesser included. It has to be in there. So it has to be in there. So yes, hopefully that helps. The only way you can bring in lesser includeds is if they are necessarily in there. Are there timestamps for the other jury's questions? Yes, there are. Those were when we first streamed this morning. So yes, go all the way back and then come back. You'll see if the chat changes. Let's see. Did Jackson ask her to ignore the question? She said the defense said ignore it. I don't know if Jackson asked. Jackson said I didn't. So I don't know. And again, you don't know if somebody says, and this, we're treading closely. If an attorney said, and this is hypothetical, we do not know what happens at sidebar, but if an attorney says, do we need to answer this now? Could that be interpreted as, well, y'all wanted to ignore it. Jackson's like, I didn't say that. Could have been Yannetti, but she said to Jackson, I mean, the defense wanted to ignore it. And he's like, I didn't say that. She did say defense. She did not say Jackson. Let's see. We're going to get to some more statements. Cindy said, how much money was spent on an OUI charge? I mean, substantial amount, but they did charge a bunch of other things. I don't know if we would be here if they had charged it as a DUI OUI at the beginning. I don't know. I really don't. Gil Juanita Molina said, EDB, thank you for teaching me lots of stuff. I hope that's lots of stuff and not lost stuff. But either way, my brain loses things sometimes too, so I'm going to use them synonymously. Also, permission to address you as my sister from another mister of 100%. 100% motion granted. We need a motion granted. Jackie B said the court sounds annoyed, but we saw this coming. The jury's confused. I hope that it has resolved. There is an update from Sue O'Connell, who said, per Karen, which seems to indicate Karen was answering questions when they left court and the defense has left court. The fourth question came in before they answered the other 3, not after. That's what we suspected. It's nice to have that clarification. That's what we thought happened. Yeah, that's what we thought. Let's see. What time do you have to leave for your flight? I've got a little bit of time. Not a lot, but I got a little bit of time. Question asking again because of scrolling. Are the jury questions? They should be timed. Oh, the jury questions in court, not unless the jury does it. There would be a record of when the court receives them, but the jury wouldn't necessarily write that on there, so we wouldn't know. I thought you meant, did we timestamp the stream when we went over them? Emily, you're just thinking of streaming and not court. Yes. No, the jurors don't always write when they're sending out the questions, and it really depends on the clerk if the clerk writes it down when it comes in. And it seems like the three, and also we don't know what happens at sidebar. So at sidebar, the court's going to say we received this at this time. And that's not on the record for us. It's in sidebar and those are sealed. But they all came in today, and it does seem that they came in the middle. I've got a little time. I'm going to answer some more questions. We're going to see where we get to. I'm going to answer some questions. If we need to stop the stream and restart a stream, if anything else happens today, we will. The jury has, let's see. It's 2:25. The jury gets dismissed at 4. They've got a little bit of time. Let's see. Emily, if they don't convict her of the greater of any offenses of the charge, they cannot convict her of any of the lessers. No. Rosebud, I'm glad you asked. We're going to try to clear up the confusion. Hold on, let's pull this up. This is the only charge with lessers. If they've got the jury instructions on this, the way that they were told to go through the jury instructions is go to number 2. If number 2 is a not guilty, then go to number 3. If number 3 is a not guilty, then go to number 4. If number 4 is a not guilty, then go to number 5. Where the frustration is that the defense would like somewhere where you can indicate that you decided not guilty on 2, not guilty on 3, not guilty of 4. So if they can't decide on 5, it's written that they couldn't decide on only 5 and that they did render a verdict on 2, 3, and 4. That's what the defense was asking for. So they can not guilty on 2, not guilty 3, not guilty 4. And then it seems that the conversation they're having is around 5. The defense wanted somewhere to put it because the defense doesn't want them only left with not guilty of the offense charged or any lessers, because what if they couldn't decide on 5 and then there's nowhere to put it? And that's hard. And that's where some of the frustration is. And you can understand it. But it says if you find not guilty on the one, then go to the next one. The defense said, can we have a box where they can just mark it? So, why is the jury form a simple considering the weeks and weeks of trial and vital final point in trials not standardized when it comes to checking the boxes? It is in a lot of jurisdictions. The court said this was the standard one. I've seen differing opinions on that, but the verdict forms are generally standardized. However, Alessi and Jackson work in different jurisdictions. So I can understand a lawyer being like, no, I don't think this is the best way to do it. I work in a jurisdiction where we do it differently and it works better. So the judge seemed frustrated today. That's not different from other days, but yes. Last question. What song recommendation do you have for C-section jam session? It really depends on the vibe. It depends if you want a mellow vibe or a high energy vibe, or something to take your mind off it. Pick something that will take your mind off it. It's a weird experience. I've been there. It's a weird experience. Something that will just take your mind off of things. So whatever your favorite is in the moment, it's pure vibes. Sometimes that might be, I don't know, for me, something like a Sum 41. Sometimes for me, it might be DMB. It just depends on what takes your mind off of things. Something familiar. Can the jury deliberate with the questions pending? Yes, they can, Gina. They often don't like to because they want their question answered. And it's It's annoying. We're like, we have a question. We've hit a roadblock. We have a question. And then 45 minutes later, it's like, here's an answer. It's like, I found a question. I wanted it answered. It takes time. It takes time. I cannot parse the letters right. Real T Squad? Really T Squad? Real Squad. I can't make the ones in the middle go in the right order. Where are we flying to next? I'm flying to a Dave Matthews Band concert, and we'll reconvene after that because Emily needs a few days off. But we will see what happens in the Kohberger case. I will be covering that next week. If Kohberger is next, then it's next. If Kohberger is not next, then probably Adelson. But we'll just look at the docket after this. I can't even think about any other case other than this right now, to be honest. I'm like, what are we doing next? I'm going to see Dave. I'm going to breathe. So Aaron said, shout out to my girlfriend in the next ER bed. We thought we'd be flying home. Oh, I'm so sorry, Aaron and Heidi. We thought we'd be flying home, but a reckless Cybertruck landed us here. Love you, Heidi. So glad you're okay. Aaron, Heidi, I'm so sorry. And I hope you are well. The Law Nerds are going to send you all of the speedy healing wishes. I am so sorry. That is the fucking worst. Fuck that shit. Heal quickly. Hopefully they at least are lovely to you in the ER. Old Lady Bakes asked a question right on point to what we were talking about, which is, hold on, let me get there. We've got a lot of super chats. I'm going to try to fly through them. We're going to start to speed run in a minute. What is the definition of included in the lesser included charges? Included means that all of the elements of the other offense are included in the greater offense. So when I was talking about this one, you have a charged, it's hard to see me, hold on. You have a charged manslaughter while operating a motor vehicle under the influence of liquor. That means that the grand jury would have had to determine that there was a driving under the influence of liquor. So chat was frozen for a minute. It means that all of the elements, A, B, C, D, has to be included in the greater offense. So it can't be that there's a few different elements. They all have to be included. So to have a manslaughter while operating a motor vehicle under the influence, all those other crimes, every single element in those other crimes is also in the greater crime. So it goes with the elements. That's what it means. All the elements must be there. All right. We're going to speed run some questions. And then if we have not heard anything, I am going to give us a break so I can pack. And then when we hear something, we will go live again if need be. So let's speed run some questions and then we'll get from there. The defense left the building, so we will have at least a 10-minute window. And that will give us at least a 10-minute window. So let's move through. Gail, good to see you. I hope to explain things, and occasionally I just scream with you going, what the fuck is happening? Jade says, this jury sounds really savvy and thoughtful. I liked their questions. I appreciate their questions. Runkle, good to see you in the chat. This was from much earlier. The jury is entitled to lunch. I'm surprised that we have not heard more from them at this point. A little bit surprised. But juries are juries. And if they're talking about that one case, one charge, they didn't really get the answers they were looking for. Which is why I would have preferred, I mean, you know what I would have preferred. I've said it about 12 times. I would have preferred if they had said, if you reach a verdict on any indictment, please fill out the verdict slip. Jury can come back and return 2 verdict slips and then go back and keep deliberating. That can absolutely happen. Can absolutely happen. So we're going to speed run questions. If we don't hear from the jury, we're going to take a break. I will app notify you if we go live again today. If the jury comes back with more questions or anything, we will go live again. I'm going to run around and try to at least put clothes in an area where I can pack them. Pharmacist Karaoke said, why do I feel like this is what a teacher would say when I would ask a question during an exam and they would say, pick the best answer? Yulon said it's been a ride. I mean, is everybody on the roller coaster today? Like, it's like everybody. Like, just everybody. Brianna said, EDB, please shout out my husband, Michael. Is it Agnew Weber, Brianna Agnew Weber, and her husband, Michael? I feel like we're on Coast to Coast After Dark. Michael. Replay crew, Michael. 2 days ago, you celebrated your 12 years of marriage. He's my best friend. Congratulations. I hope your best friend answers the phone when you call. Emily, you're still salty? A little bit. 20 plus years of marriage. I'm like, could you just keep your ringer on? Just a little bit. Congratulations on your 12-year anniversary. And the thing I have found with marriages that last well is having a sense of humor. There has to be an underlying friendship, mutual respect, and grace. It is so needed. Communication goes into that. Dancing Beagle says, they obviously forgot 8th grade note passing protocol. Check yes or no. Correct. If this doesn't mean that, yes, no. If the judge won't thoroughly explain the jury slip, I mean, it's frustrating for jurors, though, when they just want a solid answer to help them formulate a way to move forward. Sarah Torrance said, given the circumstances of the night, shouldn't all the individuals that were allegedly drinking and driving be investigated for DUIs as well? It is harder to prove when it comes to a Jen McCabe or the Alberts or whoever. In theory, yes. Karen Reed is the one who was put on a hold, who had blood drawn, and who was charged with other crimes. They didn't charge her with just a DUI. The reason Karen Reed is charged is because of their investigation and everything else. There's a lot of conversation that can be had around that, but they weren't investigating anyone for DUI that night because nobody was just pulled over for DUI. It was an after the fact, lesser included. And she wouldn't have been charged just with that. I mean, maybe they could have pled on that, but they didn't. Colleen, thank you for the gift of memberships. Can the jury convict on 1 and 3 and the OUI? Yes, but it would, I mean, in theory, but it would be a really weird result. Because, yes, they could also do that in the inverse. It would be a weird result because 1 and 3 require quite a lot of intention and knowing. So it requires a lot of intention and knowing. Alicia said, if convicted on the OUI, would she be taken into custody? I think that would be very unlikely. LTL Media said, Emily, I sat in the courtroom during trial 1 and trial 2. The courtroom is very oddly shaped and a lot smaller than it looks on TV. It looks tiny to me on TV, but I imagine it is smaller. It is a horseshoe shape with everybody in the middle. And then the attorneys, like the prosecution sitting right up where the judge is. And the judge is like, oh, it's a weird shaped courtroom. I don't like it. It's weird, but thank you for the input. It looks small to me on TV. And even when I've seen photos of it, it looks like everybody is just right there. Scrange said, why couldn't they just do the OUI separately? I mean, they didn't charge it that way. In theory, they could have, but they didn't. They charged everything else. They didn't charge it separately. Lord Castilian said, does the question give you an idea of what the jury is thinking? It did. And then that other question gave me pause. So now I have pause. Spunky Spike says, what is the app you're talking about? The Lawnerd app. We built it for you to keep you in the loop because when I'm live, we can't tell you I'm live more. So we send you app notifications through the Lawnerd app in the iOS and Android App Store. They called her Karen in the jury note. They did. They did not refer to her or as the defendant. They did. Does the jury have the actual charge list against Karen Reed? They have the verdict slips. They do not have the indictment. And then they have the jury instruction on each charge. Let's see. Just Jill said, if they are hung on OUI, is that the only part that could be tried again? It really depends on how they express that. So that is a bit of that unfortunately is a bit too hypothetical. hypothetical because it depends on how they express it. Because this is why the defense is mad about these verdict forms. There's nowhere to just mark not guilty for count 2 if they are hung on the lesser includeds. If they want to, there's not really any way for them to do that unless they put not guilty on the offense charged and then crossed out the rest of it. They would have to modify the form. There's nowhere for them to say not guilty on 2, 3, and 4 and just leave it blank. There's nowhere for them to do that. And that's part of what the defense was frustrated with. Because if they just leave that form blank, if they leave that form completely blank, then there's no verdict on that charge. Let's see. Lilibeth Van Dyke said, "You're awesome going through a hard time, and these lives are keeping me going. We're here for you, Lilibeth, and the Law Nerd community is amazing for that. So make sure you are in the chat connecting with the other Law Nerds. We are here." Jess said, "What info do you think the jury will be shocked to learn when their service is over?" I don't know. Maybe more about Proctor. I haven't really thought about it. There's probably more than that. How much they don't know is kind of overwhelming. There's a lot they don't know. So, let's see. Janice said Hoopastank was my college soundtrack. It's so good. Savannah said they said 2 charges, but there's 4. Is that worrisome? There's 3 charges. So it's not worrisome to me, Savannah, because there are only 3 charges. There are 3 indictments. Count 1 is an indictment. Count 2 is an indictment. Count 3 is an indictment. I read it as they are confused on the verdict slip on count 2, taken with all the other questions. Music to My Soul. I'm asking an important question. When you say that album was out when you were in law school, are you referring to Lily White or Busted Stuff? I'm referring to Busted Stuff. Lily White was out before that. Busted Stuff was released when I was in law school. And there are times it still takes my brain a minute to substitute out the Lily White version for the Busted Stuff version, especially when I'm hearing it live, because it can be difficult. When I saw Dave in Vegas, hold on, what song am I thinking of? When I saw Dave in Vegas in February of 2020, A, it was an amazing show. B, it felt kind of faded. And C, they played a song I'd never seen live, which is one of my favorites, Beach Ball. And I love it. But they played one of the songs off of Lily White that I had also never seen live. And it was so freaking amazing. They played Sweet Up and Down. And I've never seen them play it live again. But to see Sweet Up and Down and Beach Ball in one concert. And then we got home and we're like, oh, just kidding, world. That's rain on my end if you hear it. That's rain on my end if you hear it. Thanks for screaming with us, EDB. Much love. Enjoy, Dave. I mean, I am with all of you going, what is happening? Thank you, all of the weather apps, for my alerts. I appreciate those, but that's not helping me know what is happening. Patricia said, not case related, but I sport many tattoos and was wondering, how many do you have and do they have special meaning? Patricia, we will do this on a members only live, I promise. But 1, 2, 3, 4, 5, 8 or 9. I would have to count more, and yes, they do. Go Pack, we need you for when something else happens. That's fair. Thank you for keeping me distracted well at the dentist. Sarah Shuffles, you're welcome. Okay. All of our new members, welcome. Everyone who gifted memberships, welcome. I do not see anything else from this jury. Nothing. It just is completely radio silent at the moment. I am going to go Pack. If we go live again, if the jury just gets dismissed at 4, I'm not going to go live while the jury gets dismissed. I will let you know in the app. If something else happens, I will go live. We will go live. For now, they are back deliberating. They are taking a little longer than I thought, because that's a whole thing. But it's just a thing. Dubra79, will Jackson ask to poll the jury this time? Oh, we're far away from that, but there will be lots of stomping up and down. Ashley, sorry, that is loud. Ashley said, if they verbalize to the court that they are hung on the simple OUI, do you think it would affect the decision to retry? I think it would affect the way that they ask about giving them options on the verdict form. There's a lot of steps. There's a lot of steps. There's like a lot of steps. Caitlin, shout out to my 17 Special Olympic athletes leaving for the Summer Games on Friday. So proud of them as their head coach. Much love to my assistant coach, Amanda, who I turned into a law nerd and is watching. Caitlin, good luck. Congratulations. Please, if you don't email us in the law nerd chat, please shoot me an email and let me know how it goes. Have the best time. Can't wait. And congratulations to you and all your athletes. It's amazing. Why are super chats so wild with autocorrect? It's a YouTube thing. I have no idea. Like, I have no idea. It is something we've brought up. You know how I feel. There are things in the chat I would love to get answered that haven't been. So everything can be unchecked and only check 5. Moonal, yes, exactly, on that verdict form. Do you still have the singing pickle? Can you play it, please? Lilibeth, per your request, we are going to singing pickle. Oh, it is very rainy. Backline said, hi from a Nashville legal nurse. My building was on fire earlier and I was watching your stream while we were evacuating. I'm glad you evacuated before all this rain came through. Thank you for the work that you do, and I am so sorry. We're going to do a singing pickle, and then I'm going to pack. And then, if anything happens, we are going to let you know and we'll go live. Ready? All right, singing pickle. It's time for a pickle cleanse, and then we're going. Law nerds, let's go. It's time for a pickle cleanse. It's been a minute. If something happens in court that we need to go live for, I'll go live. If the jury just gets dismissed for the day, I will send you an update in the app and say the jury's dismissed for the day. Fingers crossed, we'll see what happens. I'm surprised, given the questions from this morning, that we have not heard back from them yet. I am. But they've still got time in the day. It is 2:45 local time. They have like an hour and 15 minutes before they get dismissed for the day. So we'll see. Law nerds, make sure you have the app, lawnerdapp.com, free on iOS and Android. We will be sending app notifications the second I know I'm going live. We send those first, even sometimes before we push the live on YouTube. Thank you for hanging with me today. Thank you, mods, for riding into stream the last moment. Today is not done yet. There is still a lot of day to go. So law nerds, take a breath. We will let you know. I know it's hard to get anything done. You feel like you're in limbo. The jury gets dismissed around 4. If we get to 4 p.m. Eastern and we don't hear anything, it means we're going over into tomorrow. So we'll see what happens. I'm surprised they didn't come back more quickly given those 3 questions, but you never know. All right, law nerds, I'll see you soon. Maybe today, maybe tomorrow. Hey there, I'm lawyer and legal analyst Emily. That's not the outro. Girl, that's not the outro. That's not the outro. It's like hello and goodbye. All right, aloha, Law Nerd. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court and, of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.